Mr. Speaker!
Please be seated. Order. When you're invited to sit, it means you take your seats. Please take your seats. The Secretary will read the 17th order of the day.
Consideration of report of Portfolio Committee on Justice and Constitutional Development on Legal Practice Bill.
I now recognize the Chief Whip of the Majority Party, the Honorable Chief Whip.
Honourable Speaker, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? Are there any objections? And I'll put the question. Those in favor will say aye. And those against will say no. I believe that the ayes have it. Shall we proceed? If there are any objections, these will be noted. No objections agreed to. The Secretary will read the 18th order of the day.
Second reading debate, Legal Practice Bill.
Thank you very much. I now recognize the Honorable Minister of Justice and Constitutional Development, the Minister.
Mr. Speaker, Deputy President, honorable members, today we as a nation stand at the threshold of a complete renewal of the South African legal system, a system that will not only be anchored on the rule of law and democratic values and principles enshrined in our Constitution, but also that which will be embraced by all people of our beloved land. The legal profession has always been a tightly regulated profession because it operates in a much regulated space. What to do, how to do it, and when to do it is regulated by different forms of legislation and prescripts, including the Admission of Advocates Act, Attorneys Act, rules of court made by the Rules Board of Courts of Law, practice directives made by Judges President, and rules made by the Bar Councils and other statutory law bodies. Different role players, including our government, will and must therefore always have a right to have their say on how people who go about their business in our courts and who conduct their profession in a public space in the pursuit to justice for all. The legal profession does not only operate in its own space, but also operates in a space where all our people, rich and poor, converge in pursuit of justice. The roles of government and that of the profession must be seen against this backdrop, with particular reference to government's legitimate interest to ensure constitutional imperatives are complied with. Transformation of the legal profession is one of these constitutional imperatives. The legal profession constitutes part of the judicial machinery that provides services aimed at promoting access to justice. Advocates and attorneys are different in many respects, just as they are similar in many respects. They belong to different regulatory bodies some statutory entrenched, for instance, the provincial law societies regulating attorneys, and some voluntary, including the General Council of the Bar of South Africa and the Law Society of South Africa. They undergo different vocational training programs, compulsory in the case of attorneys, but voluntary in the case of advocates. They prefer different names, titles, and status, some entitling the bearers thereof to higher fees for the same services. They charge different fees and use different methods to recover the fees, attorneys directly from clients, some advocates through attorneys, and some through direct charges. Yet, they all have exactly the same academic qualifications. They can appear in the same courts and represent the same people before the same magistrates, the same judges. The premise for the regulation of the profession stems from our Constitution, which enjoins the state to regulate any occupation, trade, or profession. The Bill of Rights guarantees every citizen the right to choose any trade, occupation, or profession freely and trust this democratic parliament, the legislative authority, to make laws for the regulation of such trade, occupation, or profession. Democratic principles that should govern the legal profession are geared to ensuring that our people not only blindly contribute to the revenue of those who represent them, but also have a voice in the policies and practices that affect their lives. The Legal Practice Bill has a long history, a history that has been characterized by compromises and concessions in order to get us where we are today. And one of the original aims of this long outstanding legislation was to bring about fusion in the legal profession, in which there would be a single category of legal practitioners and in which there would be no longer attorneys or advocates. This bill before us was introduced into Parliament, was adapted to accommodate the urgent pleas of the profession in order to retain the attorneys and advocates professions as distinct categories of legal practitioners, each continuing to provide the legal services traditionally rendered by each of them. Honorable members, lessons from our painful past are important in shaping the future envisioned by our Constitution. The intolerable suffering endured by our legal stalwarts describes the history of what has become known as a noble profession made up of learned friends. The agonizing experiences of Dumanogwe, the first black advocate to be admitted by the Johannesburg Bar, and those of Bram Fisher sum up what life was like in the advocate's profession under apartheid rule. The somewhat fearless fight put by the Johannesburg Bar in 1956 to allow Bram Fisher to have chambers in Johannesburg fell on deaf ears as the government of the day refused bluntly to accede to this request. Ironically, a decade later, the same bar moved for Bram Fisher to be struck off the roll for his involvement in the struggle for justice and freedom. The humiliation and anguish endured by our iconic and statesman President Nelson Mandela and one of our greatest leaders, Oliver Tambo, who opened their legal practice in Chancellor House in downtown Johannesburg, mirrors the hardship of an African attorney at that time. The Transvaal Law Society moved for Nelson Mandela to be struck off the roll, which application was turned down by the Supreme Court. It was through a combination of the oppressive policies of the government of the day and the ill-fated policies of the profession that lawyers of the generation of Tambo, Mandela, Nogwe, Fisher, Griffiths, and Victoria Mxenge, and others were deprived the opportunity to practice their profession freely. The practitioners of yesterday did not have the protection of the rule of law, and some members of the judiciary were also against them. The lack of the rule of law and the system of rule by law made the acts of the apartheid government legitimate in the eyes of the so-called law then. Mr. Speaker, we tell these unpleasant stories of our past because we want to learn from our past in order to strive for a perfect future. The enactment of this bill provides the opportunity to redeem our past, sad as it was, and lay a firm foundation for a promising future for advocates and attorneys. The enactment of this bill carries with it the hopes and aspirations of many of our people on either side of the courtyard. On the one side, the bill extends the legal practitioners and aspirant jurists whose unrelenting desire to be freed from the shackles of apartheid to become true agents of the rule of law that has been long drawn-out journey with several stop streets, and on the other side, it brings hope to millions of our people whose quest for true justice is beyond measure. This bill advances the transformation goal of our Constitution and complements the institutional reforms already introduced into our system by the Constitution 17 Amendment Act and the Superior Courts Act. These triple acts, all of which have taken time to find their way into the democratic parliament, collectively seek to enhance access to justice, strengthen the independence of the judiciary, and safeguard the rule of law which underpin our constitutional democracy. As we begin the countdown to our 5th general elections and the celebration of 20 years of our constitutional democracy, we also must take stock of the gains we've made in our transition from a tribal and apartheid past to a stable constitutional democracy. The enactment of all these bills before Parliament add to this successful transition. As we forge ahead as a nation, we remain resolute that the rule of law is an indispensable bulwark of our constitutional democracy and a fortress of our independent judiciary during this period of transition and beyond. The National Development Plan, our plan, articulates a very clear program to create full employment, eliminate poverty, and significantly reduce inequality. In respect of the legal profession, the development plan advocates for measures aimed at increasing the intake of female practitioners within the legal profession. I'm certain government and legal profession, within the space provided by the NDP, work together for the common good of the nation. The idea of a consultative forum signifies a fundamental breakthrough in addressing contentious aspects of this bill. The bill is still not a consensus bill in all respects. Complete consensus became an impossible task, and this is borne out by the almost 20 years of negotiations. But now we've reached the stage where we simply have to forge ahead. It is in this context that I want to thank all statutory and organized formations in the legal profession for remaining part of these deliberations to this end. I wish to mention the General Council of the Bar, all bars, independent statutory law bodies, NADEL, which I'm very grateful for giving me employment in my earlier career in law, Black Lawyers Association, Advocates for Transformation. In conclusion, I want to thank the chairperson of the Portfolio Committee and all fellow members for their guidance, sterling leadership for navigating this bill. Director General for providing technical support. Of course, the Deputy Minister, Jeffrey, who has played an important role in enhancing the objectives of this bill. I trust that this House will support this bill, which has been a long time coming. Thank you.
I thank the Honourable Minister, and I wish to invite the Honourable L.T. Lenders.
Honourable Speaker, Honourable Deputy President, Honourable Ministers, Honourable Members, it is always an honour to follow the Honourable Minister of Justice. The African National Congress will vote in favour of the Legal Practice Bill. To say that the Legal Practice Bill is complex and complicated is an understatement. The Legal Practice Bill is 120 clauses long, and it seeks to transform an extremely conservative and yet fragmented sector of our society. 20 years in the making, the legal profession has until now successfully resisted change and transformation. During the committee's deliberations on the bill, it received both written and oral submissions from a large cross-section of members and organizations from the legal profession and other sectors of civil society. We will make reference to some of these submissions during the course of this debate. The opinions, views, and positions put forward during today's debate reflect somewhat the diverse and conflicting positions within the legal profession on the matter of transformation. You will hear today the view expressed that the status quo should remain, that the legal profession does not need transforming, and that any attempt to do so will adversely affect the independence of the profession, and therefore, by extension, any transformatory measures provided for in the bill also adversely affect the independence of our judiciary. This is borne out by the fact that when the committee agreed to a provision allowing advocates to accept briefs directly from the public, it was described by the GCP chairperson, Advocate Ismail Semenya, as the beginning of the end for the advocate's profession. The African National Congress firmly rejects the view that the transformation of the legal profession and any transformatory measures provided for in this bill will adversely affect the independence of the legal profession. Of course, at the public hearings conducted by the committee, we had no less a person than the esteemed Advocate George Bizos remind the members of the legal profession who were present that for so many years people like him and others had warned them to get their house in order and to bring about the long overdue changes that they had stubbornly resisted. That failure to do so would result in transformation being imposed on them by members of Parliament. Of course, there were also other significant submissions made to the committee. One of these was from the Independent Association of Advocates, who proposed that members of the advocates' profession be allowed to accept briefs directly from members of the public. The committee has agreed to this proposal. Consequently, Clause 34, subsection 2, sets out how this is done. As motivation for its position, the Independent Association of Advocates made the point that direct briefing of advocates, or barristers as they are called there, is allowed in Britain, from whom South Africa inherited its legal system. Another significant submission was made by the Competition Commission through a Mr. Bonagela, who felt strongly that the public disclosure of briefing patterns by the super users of the legal profession, for example, banks, would force the diversification that is so desperately needed in the profession. An example of this can be found in New York. Regrettably, Honorable Speaker, Honorable Minister, this aspect was not dealt with by the Portfolio Committee. The fragmented nature of the profession was demonstrated when the Law Society of South Africa appeared before the Portfolio Committee. On the one hand, you had elements in the Law Society lamenting the fact that the bill fails to provide for a single, unified body representing the legal profession in South Africa, as is the case in all other SADC countries. On the other hand, Jan Stemmert's approach was that government should merely provide for the framework in which the profession should exist, but that government should not run the legal profession. Needless to say, and I do not intend to speak on behalf of the government, but it is common cause that government has no intention of running the profession. Jan Stemmert then went on to say that the proposed legal services ombud should be proposed by the Chief Justice, but he failed to set out how this should happen. We rejected this proposal. However, the committee has conceded to the ombud being appointed from the ranks of judges who are retired from active service. Probably one of the most revealing submissions made to the committee came from the Chief Executive Officer of the Attorneys Fidelity Fund, Mr. Mhlatsi Molife, who pointed out that 60% of the Fidelity Fund went towards propping up the Law Society in 2012. More importantly, the CEO stated that theft by legal practitioners in South Africa is growing exponentially. Aside from ensuring adequate policing of the profession, the CEO believes the fund must be given the independence it needs. Failure to do so could result in the Fidelity Fund being rendered bankrupt, as has occurred in New Zealand, and I wish the Honourable Richard Mdagane to take note of that. Chapter 6 of the bill seeks to address Mr. Malife's concerns, which are shared by most, if not all, committee members. Other notable features of the bill that will be addressed in more detail during the course of this debate are, amongst others, community service for legal practitioners, the fact that all disciplinary matters involving complaints against legal practitioners must be conducted in an open, transparent forum where the complainant, the public, and the media can follow the proceedings, including the publishing of particulars of such matters on the Legal Practice Council's website, together with the Code of Conduct for the legal profession, which the Legal Practice Council will draw up. Advocates who opt to accept briefs directly from the public must be registered as such with the Legal Practice Council and have to obtain a Fidelity Fund certificate. Consequently, such advocates will have to contribute to the Legal Practitioners Fidelity Fund, to give it its proper title, in the same way that attorneys do. Entry to the legal profession is a serious challenge for many aspirant practitioners who face restrictive and outdated prescripts compounded by disparate laws that only apply in different parts of South Africa. Access by members of the public to obtain legal services from the profession is also limited. The Constitutional Court's pronouncements on the exorbitant fees charged by certain members of the profession also compounds this challenge. But when you put to the organized profession this particular challenge, they respond in unison: legal aid, pro bono, legal aid. Honorable Speaker, we want to use this occasion to call upon the legal profession to draw together and embrace this bill to ensure meaningful and proper implementation of all its provisions. The 2-year intervening period leading to the establishment of the proposed Legal Practice Council will serve as a challenge to the legal profession to demonstrate its willingness to embrace transformation. The legal profession dare not fail. Allow me, Honourable Speaker, to express my thanks, firstly, to all the members of the Portfolio Committee. A particular word of thanks to the Honourable Deputy Minister of Justice, Mr. John Jeffrey, who was appointed as Deputy Minister whilst he was a member of the Portfolio Committee and had made some crucial amendments to the bill before us. We also want to convey our thanks to Mr. Lawrence Bassett, Mr. Raj Daya, Mrs. Vilma Lowe, and Ms. Lufundo from the Chief State Law Advisor's Office for the invaluable assistance they accorded the Portfolio Committee during its deliberations. I thank you.
I thank the honourable member, and now we should invite the honourable Smarts to the podium.
Mr. Speaker, a wave of regulatory reform of the legal professions has been washing over the common law countries. Always, the reasons are the same: affordability and access, choice, competition, and consumer protection, especially against ineffective professional disciplinary mechanisms. Now, we have scratched the surface and legislated some improvements: transparent disciplinaries, appeals, also for complainants, an ombud, who is a discharged judge, cost estimates for clients. This last was a DA proposal, so that clients will know what they are in for, what costs. The discharged judge is there at the insistence of the DA. So we have therefore made some improvements. But what we should have been doing was we should have been setting up an appropriate regulator. The new regulators created elsewhere to address these same problems we face are typically small bodies composed of lay persons with relevant expertise, a few advocates and attorneys, and sometimes government representatives. Form follows function. Instead, what is South Africa doing? Here is what South Africa is doing. The Legal Practice Bill forces advocates and attorneys into one governing body, the Legal Practice Council, and then it puts the attorneys in charge. Why has this happened? It has happened because the ANC, to borrow the title of Professor Sampieter Blanche's latest book, is lost in transformation. You are lost in transformation. At transition, sir, and the Honourable the Minister has alluded to this, there was some consideration given, but let me now use the words of the chairperson of the General Council of the Bar, Advocate Ismail Semenya, and I quote, "There was some consideration given to what might be called naked fusion, and for so long as that was the case, the role for a legal practice council in the governance and regulation of lawyers was clear," unquote. The idea of fusing the advocates' and attorneys' professions outright was abandoned, as you have also heard. But the bill with its legal practice council has stubbornly survived through 5 justice ministries. It is fusion in disguise. The thinking behind this fusion by stealth has been perfectly honestly stated by the ANC members of the Justice Committee. The Honourable Dr. Mochecha cited the case of Zimbabwe, where he was present when fusion was effected at transition. But he doesn't say, maybe he doesn't remember, that 99% of advocates in Zimbabwe were white, and they had the sole right of appearance in the higher courts. The Honourable J.B. Sibanyone has twice recounted how, at transition in South Africa, the then statutory municipal formations sat on one side of the negotiating table, and the extra-parliamentary local government groups on the other side. Negotiations resulted in what he called wall-to-wall local government. Discussion on fusion, he said, then followed in Nadel. Now, to the Honourable Sibanyone, the divided legal profession is the inherited old order. The logic and applicability of his argument is not clear, and I look forward to perhaps hearing him on the subject again today. The logic is not clear unless advocates are assumed to be the embodiment of the inherited old order. And that, sir, is no doubt why a unified profession was the stated goal of the bill at earlier stages of the legislative process. But because the bill does not discontinue the statutory recognition of the advocates and the attorneys' professions, a unified regulator was chosen instead of a unified profession. And some attempts were made to create tasks for such a thing after the fact. But the essential goal remaining for the unified regulator is, and I quote from the bill, transformation and the broad reflection of diversity and demography. However, sir, the truth is that significant progress has been made in deracializing the legal professions. This is no longer 1994. As at March 2013, 64% of our 21,463 attorneys were white and 36% were black. Black law graduates started outnumbering whites from 2005 onwards. Black articled clerks from 2009. At the GCB, white males represented 1,379, call it 1,400, of the 2,400 plus members at April 2013. And the black professional bodies have long been integrated with the GCB and the LSSA, respectively. Now, the position of the General Council of the Bar, having tried in good faith to work with a single legal practice council, was that there should be 2 separate chambers for advocates and attorneys, logical, at the national and the regional level. The position of the Law Society of South Africa was that policy should be set by the majority at the national level, that is by them. That is 10 attorneys as against 6 advocates. They quite like that. But that given the significant regulatory differences characterizing the 2 professions, there should be separate chambers at regional level for implementation. The departmental response, obviously speaking on behalf of the political heads, to these submissions was a dead giveaway. It was this, it said this, the chambers, I quote, boils down to the retention of the current arrangements. The department is of the view that this will perpetuate the issues that the bill seeks to transform. In other words, the bill seeks to transform the advocates and the attorneys' professions. They can't go around regulating themselves because that's too much like being 2 separate professions. And so it was When the ANC guillotine fell on almost all of the DA proposals, there are no chambers at any level, not even the committees with original non-delegated powers we proposed as a compromise, nothing. The policy making and the operational power lies at the highly centralized national level in the Legal Practice Council. This consists inter alia of the 10 attorneys and 6 advocates. In vain did I argue for parity. There was a moment when Dr. Motshekga and I, between the two of us, actually achieved parity, but somebody stepped in and he reneged. There is no guarantee that advocates will be able, by the way, to elect their own half dozen. This is so because the Council will be preceded by a carefully constructed and controlled interim national forum, whose first order of business will be to create an election procedure for the actual Council. It is thought that this will be based on a voter's roll of all legal practitioners. Also on the order of business, wasting no time, is to write one code of conduct for both professions. In other words, attorneys will, by majority, make regulatory policy for advocates. The chair and deputy of this interim body are chosen by the minister after consultation with the National Forum. If they become vacant, he calls the shots again, and the chair has a casting vote. Mr. Speaker, now just to rub in the bill's levelling fusionist intent, the DA's previously acceptable proposal, there was no sign that it wasn't going to be written into the bill. The previously acceptable proposal that the chair and the deputy of the Legal Practice Council should represent both professions. In other words, if an attorney was chosen chair, the deputy should be an advocate and vice versa. It was simply thrown out at the last. In addition, the further 5 members of the executive need only, as far as practicable, be representative of both attorneys and advocates, and gender and race. Mr. Speaker, the advocate's profession has been sold down the river because the ANC is lost in transformation. And yet fusion is a delusion. Even in countries where full fusion was introduced, the bars arose again. We need the advocates. Now, we believe South Africa specifically needs the split or divided profession. An advocate practicing on the traditional independent basis will take on politically and socially unpopular cases. And this remains as necessary now as it was in the old South Africa. We can recite the sins of the old South Africa as often as we want. You need the independent advocate as much now as then for the politically unpopular and the socially unpopular cases. In addition, the quality of advocacy has a direct effect on the quality of judgments handed down by the bench. And no, the relaxation of the referral rule had no effect on the advocate's profession elsewhere, neither will it destroy it here. I am in favor of the relaxation of the referral rule. Attorneys, especially the small firms, and 75% of our attorneys' firms are small, that is 1-man, 2-man firms up to a maximum of 9. Those little firms should be the front line of access to justice for South Africans. And we are, by the way, confident on excellent authority that a significant number of attorneys share our views on separate chambers. There should at least have been separate chambers if you insist on fooling around with a single legal practice council. So fusion works against the interests of small attorneys because it is typical of fusion that law firms become enormous in order to offer a full range of services. By contrast, when professions are split, even the small attorneys' firms can take on complex cases because they can call on the expert services of independent advocates. We should have been working on alternative business models. That is what the regulators in all the other common law countries are also doing, so that small attorneys can make a living while serving South Africans. But we need to have a real regulator looking at the real factors at play to see why the legal services market is not finding the legal services providers. They're not finding each other. So the attorneys feel they can hardly make a living. The clients not only feel they know, they can't afford legal services. Something is wrong with the economics, and that needs to be looked at by a proper regulator. But I regret to say that I've come to the conclusion that the ANC is interested neither in the welfare of the professions nor the real interests of clients. A ministerial power of dissolution will allow the minister to dissolve the council. I think that that is shocking. We're dealing with an independent profession here. A power of dissolution will allow him to dissolve the council and to install 7 hand-picked people for 6 months. Now, no matter how many safeguards are built in, and yes, the courts have been written in, this power is in itself inimical to the independence of the legal professions, as Judge Chaskelson said in his last speech. It is also an admission, I think, that power of dissolution is your own admission that you are fully aware, Honourable Minister, that the Legal Practice Council will institutionalise the same tensions which caused its negotiation over the life of 4 former ministries over 20 years to fail. What makes you think that now that we legislate a thing that nobody wanted, hulle wil nie by mekaar wees nie, hulle hoort nie by mekaar nie, what makes you think it's going to work? I believe that we are here legislating for failure, and we oppose.
I thank the honourable member, and I wish to invite the honourable Adams to the podium.
Honourable Speaker, honourable members of this House, COPE supports all the transformative principles and clauses of the bill. The transformation of the legal profession, coupled with access to justice, must be supported by all of us at all costs, but not at any cost. However, COPE cannot support the erosion and tampering to the independence of the legal profession as envisaged in this bill. Section 22 of the Constitution provides that the practice of a trade, occupation, or profession may be regulated by law. This section obviously includes the legal profession. However, as in the case of the General Counsel of the Bar, it is COPE's submission that whilst it is a prerogative of the Minister to provide the statutory framework within which the legal profession is to be regulated by professional bodies, the state may not be involved in the governance and management of the profession. In the case of this bill, it is the intention of the Minister to both provide the statutory framework for the function of the legal profession and to be involved in the governance and management of such. If it was not the government's intention to govern the profession, then why did it deem it necessary to include a dissolution clause? COPE cannot support this intention of the Minister. The current Clause 7 of the bill is unconstitutional and it interferes with the independence of the legal profession in a number of aspects. Firstly, the insistence by the Minister of Justice to have 3 persons as designated by him to sit on this legal council is plainly known as interference. Secondly, the independence of the advocates is interfered with since the advocates will now be regulated by 17 non-practicing advocates who have not been elected by the advocates' profession. On the 7th of August 2009, in a meeting between the Minister of Justice and the leaders of the GCB, the Minister ensured these leaders that the legal practice bill will not allow the government to govern the legal profession. After 4 years, we are still waiting for this promise to become a reality in this bill. Once this bill is passed today, the legal profession will be governed by the government. The message to the legal profession in this bill is quite clear. You either shape up or ship out. You both report to the Minister and satisfy his mandate, or you will be dissolved and replaced by individuals who want to be instructed by the Minister. Die gogga maak nou vir die baba bang. The United Nations Basic Principles on the Role of Lawyers clearly states that lawyers shall be entitled to form and join self-governing professional associations. As long as the bill does not provide for a chamber for advocates and a chamber for attorneys, then the legal council cannot be regarded as a self-governing body. South Africa will thus not comply with this United Nations principle. The principle continues to state that the executive body of the professional associations shall be elected by its own members and shall exercise its functions without external interference. Again, this bill flies in the face of this United Nations principle because the legal council can be dissolved at any time that the Minister so wishes. That is called external interference. The discretionary powers of the minister in this bill will erode the independence of the legal profession. In addition to this interference by the minister, the legal counsel must annually report to the minister on a number of issues. This reporting to the minister makes the legal counsel dependent on the minister, especially since the minister's discretionary powers can determine the future existence of that legal counsel. 51 years ago, in November 1962, the president of the Institute of Race Relations made a public statement stating that house arrest of political activists opposing apartheid was an infringement of the rule of law. Advocate B.J. Foster, the then Minister of Justice of South Africa, responded to this statement by saying that there are as many interpretations of the rule of law as there are people, and that the rule of law is very easily used as a pretext for attempts to frustrate action against communism. He went further to state that an elected parliament had mandated him to maintain law and order to secure the safety of the state. The apartheid government had no respect for the rule of law, and that is why the South African citizens, including the legal profession, got rid of that government. Fast forward to today, in November 2013, and in a democratic state, the current Minister of Justice, through this bill, is advancing the same argument as that of Advocate Foster. Only this time around, the argument is that the rule of law is very easily used as a pretext for attempts to frustrate transformation in the legal profession and access to justice. And any person advocating for the independence of the legal profession is against the transformation of this profession. If any former political prisoner is in this house today, then he or she should know that the independence of the legal profession was the reason why he or she was represented in court during apartheid by an independent advocate. According to Judge Willis, he makes reference to the above, and he says that it is largely because of those traditions of independence that we were able to reconstruct our legal system after apartheid and create legal institutions that function in a democratic society under the rule of law. Coming to the current government, I want to reiterate that this government has no respect for the rule of law, and that is why the South African citizens, including the legal profession, must get rid of this government. The most loved president of South Africa, Mr. Nelson Mandela, said in 1993 in his address to the COSATU Congress that if the ANC does to you what the apartheid government did to you, then you must do to the ANC what you did to the apartheid government. COPE will not support this bill.
I thank the honourable member, and I wish to invite the Honourable van der Merwe to the podium.
Mr. Speaker, I agree with the previous speaker that it's time to get rid of this government. But I want to say to the Honourable Minister, when the IFP becomes the government next year, we will keep you as the Minister of Justice. I also thought, Mr. Speaker, that the Honourable Lounders and Smuts have made excellent contributions. They've analysed the bill, they've mentioned many comments about it, and I enjoyed both of them, although they don't agree with one another. My colleague, Dr. Ambrosini, attended meetings of the Justice Committee in respect of this bill. I, therefore, do not have the benefit of all the discussions and will thus only make some basic statements, in particular why we do not support the bill. The bill has been a major source of contention with the legal industry, with proponents and detractors. It's common cause that our legal profession requires some review, and the committee has tried to find the thin line between what was in the best interest of the public and the profession. Speaker, I will now deal with some of our important objections. Firstly, the independence of lawyers are under attack. And secondly, the minister gets the power to effectively control the judicial system. Secondly, the soon-to-be established South African Legal Practice Council will, in terms of Section 4, and I quote, exercise jurisdiction over all legal practitioners and candidate legal practitioners, unquote. This council, therefore, effectively centralizes control of the judiciary in the hands of the ANC executive. Thirdly, the creation of provincial councils will have a huge cost effect, not only money but also administrative. And I wonder where the money will come from, because a proper and in-depth budget has not been prepared. 4, as far as legal costs are concerned, the limitation thereof may assist some clients, but fees are market-related. If you want to brief the Jeremy Gauntlets, you pay them 40,000 rand a day, or he does not accept your brief. In conclusion, the bill has good clauses, but the objections I have reached made it impossible for the IFP to support the bill. The IFP will therefore oppose the bill. Sorry, Minister.
I thank the honourable member, and I wish to invite the honourable Sibanyoni.
Thank you, Honourable Speaker. Thank you, Deputy President, Ministers, Honourable Members of Parliament. I will start by saying the ANC supports this bill. The angle of my debate is transformation of the legal profession. This has been a long road that has been taken until we reached the stage that today I'm standing in this podium debating this legal practice bill. My first encounter with the topic was around 1985, during the days of the launch of organizations such as the Democratic Lawyers Congress, DLC, by Honorable Motshekga, which was eventually disbanded and became the Pretoria branch of the National Association of Democratic Lawyers, NADEL. We dabbled with the calls for the fusion of the bar and the sidebar, but we moved away from that. NADEL, Black Lawyers Association, that is BLA, and other lawyers' formations pursued the struggle. There were calls for disbanding the law societies at the beginning and the General Council of the Bar, the GCB. Is it not absurd that about 28 years down the line, the bar and the sidebar is still intact? My learned friend and colleague, a Pretoria attorney, Nano Matlala, has this to say, I want to quote: "The problem with South Africa under black rule is that the elites do not see South Africa as part of Africa, but an extension of the colonial masters. It is disingenuous to state that a single profession will not be independent. The distinction between attorney and advocate is academic, given similar university qualifications, unlike in the past, when the minimum qualification of attorney was a diploma or a junior degree in law. It is for this reason that the Constitution provides for appointment of judiciary from a fit and proper person who can be an attorney or an advocate. There is no judge attorney or judge advocate. They are all members of the judiciary. The same should be with the legal practitioners. Attorneys and advocates both appear in high courts. Post-1994, a majority of black judges have been appointed from the attorney's profession, and some are judge presidents and judges of the Supreme Court of Appeal, SCA, and the Constitutional Court. The USA is a good example of an independent and single legal profession. Its judiciary is appointed from a single legal profession. The GCB does not qualify to state that it is a public interest to leave the advocate's profession intact and to regulate itself. Attorney Nano Matlala also has this to say: over the last 15 years, I have asked many members of the public in rural and townships what the difference is between an advocate and an attorney, and the answer has always been wrong. The answer I always got is an advocate is a big lawyer and an attorney reports to an advocate. Matlala says, when I was co-chair of the Law Society of South Africa, I caused the LSA to undertake research on the legal profession in Namibia, Kenya, and Uganda. In all these countries, the legal profession is regulated as a single legal profession. In Kenya, legal practitioners are advocates regulated by the Law Society and the Advocates Act. They all take direct instructions from the public and hold a Fidelity Fund certificate. There are no attorneys. Kenya has severed the umbilical cord with the colonial masters, and this is understood or is underscored by the fact that the Chief Justice of Kenya, Willie Mutunga, has never been an advocate or a judge before he was appointed, and the nation never made noise about his appointment. Maybe we should follow the Kenya and other African countries and call everyone an advocate. The difference will be whether one chooses to take direct instructions or not, as in the position in Namibia or in the position in the medical profession, unquote. Now let me come to the work of ministers. I think you will all remember this. The late Comrade Dala Oma was the first justice minister who first tabled a bill whose objects were to transform the legal profession. There were resistance. There were extended discussions and engagements. No agreement was reached. His term of office expired. The next minister was Honorable Panuel Matuna. Again, engagements followed. His term expired. And the next was Honorable Bridget Mabandla. Also her term ended. There were colloquium, conferences and the like. And then also Honorable Enver Surti, who crisscrossed the country as an attorney talking to his learned friends. His term also expired. Now, Honorable Jeff Tamsanga Khateb, Bungane, sithi mayingaphelele ezandleni zakho njengamanzi. Bathi abakwa Bungane omthi mkhulu omfazi amabele amade encelisa umntwana ngaphesheya komfula. Sesithembele kuwo. Why the legal practice legislation is needed? No. At the present moment, the law dealing with the matters of attorneys and advocates is fragmented, and such laws are applied to different parts of South Africa. Currently, the legal practice, which I agree it was called the noble profession, does not reflect the demographics of our country, and entry into this profession is often determined by unnecessary restrictions, thus limiting the profession specifically to the poor. When one looks at the preamble of the bill, one finds the clear explanation of the objects of this bill. Among others, I won't quote them all. It is stated that it is to provide a legislative framework for the transformation and restructuring of the legal profession that embraces the values underpinning the Constitution and ensures that the rule of law is upheld. And further, it is intended to protect and promote public interest, protect and promote the interest of consumers of legal services by the establishment of an office of the legal ombud. The South African Legal Practice Council is being established to exercise jurisdiction over all legal practitioners and candidate legal practitioners. And the Legal Service Ombud, the bill establishes this office in the Republic. For instance, there is provision for the following objects of the ombud: the protection and promotion of the public interest, which I've just stated. Now, to end my debate, I want also to quote again Attorney Matlala. He says, "Today, South Africa is making history as it did on the 27th April 1994, when, for the first time, all South Africans determined the destiny of this country at the ballot box. The historical event was captured by the world in all media. It was preceded by the many years of struggle and loss of life by many South Africans of all races, not to mention imprisonment, torture, forced exile outside and within South Africa." He continues and says, "They all, the products of this bill, seeks to repeal the establishment of a united legal profession under one roof. This was also a long process and is historical. And, Honorable Speaker, South Africa has a transformative constitution. It provides for 3 arms of the state: Parliament, Cabinet, and the Judiciary. This goes along with the doctrine of separation of powers. No one arm should encroach on the territory of another. The Constitution requires all the 3 arms of the state to transform the South African society. To the judiciary, I want to say, our justice, we put our trust in you. And to ANC comrade, we put our trust in you to pass this bill today. Vandaag is vandaag. Thank you.
I thank the honourable member, and I wish to invite the Honourable Ntapane to the podium.
Honorable Speaker, Honorable Deputy President, Honorable Ministers and Honorable Members, the United Democratic Movement welcomes the purpose of this bill, which seeks to transform our skewed legal profession. It is so skewed to understand that this piece of legislation has long over been due. We also welcome the establishment of the Council. Previously, there was a willy-nilly striking of the names of attorneys, especially blacks, from the roll until they stood up and fought it by becoming part of the law societies. If one goes through the objects of council and its functions, among other things, it deals with exorbitant fees that are at times charged, which makes justice come at a very high price to the majority of South Africans. This also goes to clause 27, which seeks to regulate the payment of remuneration, allowances, or stipend of candidate legal practitioners. If honorable members, you can know how much some of these candidate legal practitioners receive from their principals, you will be astonished. It is just incredulous. However, Honorable Minister, UDM has reservations about conversion of enrollments. Legal practitioners, for them to accept or receive money from clients or members of the public, they need training as to how to handle such funds. Legal practitioners who at present are referred to as trust account practitioners are attorneys who, amongst the requirements to be admitted as such, must have been trained and passed examinations and pass accounting examinations. This is not the situation with advocates. So to just convert their enrollment to that of an attorney only on applying and payment of the fees without being trained as to how to handle funds in the trust account will at times create problems. However, the UDM supports the bill.
Thank you, Honourable Member. Honourable Albert.
Thank you, Chair. I agree with the Honourable Smits that this bill is lost in transformation. This bill is just another slew of laws generated by the ANC to transform South Africa's society into a re-racialized society where government controls everything, whether directly or indirectly, at the cost of individual and communal liberty. Equality at all costs, even if freedom is in the end undermined. That is the ANC's mantra. Die wetsontwerp op regspraktisyns is nog 'n poging van die ANC om die regsprofessie te transformeer tot ANC-beheer. Die wetsontwerp het dit ten doel om 'n enkele landswye regsliggaam tot stand te bring om die bestaande prokureursordes en balierade te vervang. Hierder word prokureurs en advokate se grondregtelike wette van vryheid, assosiasie en beroep en die eienoomsregte van bestaande prokureursordes en balierade tot niet gemaak. Die Vryheidsfront Plus sien dit as 'n kwaadlik verbloemde poging van die ANC om groter beheer te verkry oor die regsberoep, net soos die regbank ook moet transformeer om die ANC gedienstig te wees. The current system of law societies and bar councils were established over centuries and serve the interest of the public very well, despite the high cost in higher courts. We do, however, agree that costs are one of the major factors that inhibit access to courts. We also agree that it must be addressed, but not by attacking the legal profession as such. Instead, government could have looked at some form of legal insurance structure to assist the public. By merely forcing legal professionals to charge less will only ensure that substandard services will be delivered. In short, you pay for the best professional service. Even government does if one regards the legal counsel it uses. Sanral used advocate Jeremy Gauntlet, for instance. Indien die wetsontwerp deurgevoer word, sal dit uiteindelik negatief inwerk op die regsprofessie van Suid-Afrika en sal dit tot nadeel wees van al die mense in ons land. Dankie.
Thank you, Honorable Member. Honorable Philani Macheke.
Honorable Speaker, Honorable Deputy President, Minister of Justice and Constitutional Development, Honorable Members of the House, guests in the gallery, the ANC supports this bill. My focus is going to be on fees in respect of legal services. The purpose of the Legal Practice Bill is to provide legislative framework for the transformation and restructuring of the legal profession that embraces the values underpinning the Constitution. The committee is aware of the many fees-related complaints. The bill recognizes the importance of access to affordable legal services for realization by South Africans of freedoms enshrined in the Constitution of the Republic of South Africa. While seeking to attain these objectives, the bill recognizes the independence of the legal profession and seeks to strengthen independence that should entrench the principle of transparency and accountability. Honorable Speaker, Section 35 of the Legal Practice Bill focuses on fees in respect of litigious and non-litigious legal services rendered by legal practitioners, juristic entities, law clinics, and Legal Aid South Africa. Fees in terms of the provision of this Act must be in accordance with the tariffs by the Rules Board for Court of Law, as established in Section 2 of the Rules Board for Court of Law Act of 1985. The Rules Board for Court of Law must, when determining, for example, tariffs, look at the importance, significance, complexities, and expertise of legal services required, the seniority and experience of legal practitioners concerned, the volume of work required, and time spent in respect of legal services rendered, and financial implications of the matter at hand. The bill also supports the idea that nothing precludes any user of litigious and non-litigious legal services on his or her own initiative from agreeing with a legal practitioner in writing to pay fees for services in excess of or below any tariff determined as contemplated in this Section 35 of the bill. The South African Law Reform Commission must, within 2 years after the commencement of this Act, investigate and report back to the Minister with recommendations on the following: the manner in which to address the circumstances giving rise to legal fees that are attainable for most people, which is a point of contention. Legislative and other interventions in order to improve access to justice by the members of public, the desirability of establishing a mechanism which will be responsible for determining fees and tariffs payable to legal practitioners, the composition of the mechanism contemplated and processes to be followed in determining fees and tariffs, desirability of giving users of legal services the option of voluntarily agreeing to pay fees for legal services less or in excess of any amount that may be set by the contemplated mechanism, and the obligation by legal practitioner to conclude a mandatory agreement with a client when that client secures that legal practitioner service. Quite good mechanism of ensuring that the public will be protected in terms of the type of fees that will be charged when they sought or are seeking legal services. In conducting this investigation on fees, the South African Law Reform Commission must take the following into consideration: the best international practices, public interest, the interest of the legal profession itself, which is something that you need to note, because the impression has been created that it's as if the bill itself is actually taking away the independence of the legal profession. The bill also has provision for the minister to determine maximum tariffs payable to legal practitioners who are instructed by any state department or provincial or local government in any matter, just to control also the fees in that area. An attorney or advocate rendering litigious or non-litigious legal services must provide the client with cost estimate in writing, specifying all particulars relating to the envisaged costs of legal services, including fees, charges, disbursements, hourly rates, and an explanation to the client of his or her right to negotiate the fees payable. The attorney must also outline work to be done in respect of each stage of litigation process and the likelihood of engaging an advocate, as well as an explanation of different fees that can be charged by different advocates. This to also be done verbally or explained verbally by an advocate, an attorney. All of this just indicates that things are now changing in South Africa. We're now reaching a stage where legal services will be affordable. People wouldn't actually enter into agreements with lawyers on fees that they don't understand and on the processes that will unfold that will actually end up being processes that are costly that they did not actually know of or anticipate. A client must in writing agree to the envisaged legal services. Non-compliance by an attorney to do that or an advocate constitutes a misconduct, and the client will not be required to pay any legal cost to that attorney or advocate until the council has reviewed the matter and made a determination regarding the amounts to be paid. This provision does not preclude the use of contingency fee agreements as provided for in the Contingency Fees Act of 1997. In conclusion, Honorable Speaker, any change is stressful, and that is why the opposition is weary, not of the unknown, because the bill has been elaborately deliberated on by all parties in the committee over a very long time. Numerous written and verbal submissions from the public and the legal fraternity were received and engaged on. Best practices looked at throughout the world. This change that will be brought about by this bill is change for fairness and betterment of the lives of South Africans. We will continue to acknowledge, of course, selective amnesia caused by manipulation of parliamentary debate to create a campaign platform for parties like COPE that want to give an impression that things aren't fine, to create an opportunistic platform that tries to turn the good that the ANC is doing into bad. The ANC supports the bill.
Thank you, Honourable Member. Honourable Swart.
Deputy Speaker, Deputy President, the Commonwealth principles on the three branches of government relating to the independence of the judiciary and to which South Africa is a signatory states that, quote, an independent, effective and competent legal profession is fundamental to the upholding of the rule of law and the independence of the judiciary. Now, one of South Africa's most well-known advocates who practices in London, Sidney Kentridge, has stated that there are few things as essential to the maintenance of liberty in a state as the existence of an independent body of advocates ready to appear for every person in every kind of case. Now, to protect this independence, governance and the management of the legal profession may not be done by the state, and the Minister may only provide the statutory framework within which the legal profession is to be regulated. Honourable Minister Radebe is on record as saying that he does not wish to control the profession. That we in the ACDP accept. However, as Chairman Llewellyn Landers is often at pains to explain, we legislate for the future, for that unknown time when there might be another dictatorial minister in control. And therefore, the possibility of ministerial interference most definitely exists when one adds up the various powers that the minister is given in terms of this bill, including making regulations on a broad range of issues, having 3 ministerial representatives on the council, and of course, most importantly, the power to dissolve the council, albeit following a court process. Now, as the former Chief Justice Arthur Chaskelson said last year about this bill, and just before his death, he said a structure is being proposed which opens the door to important aspects of the profession being controlled by the executive, and that is inconsistent with an independent legal profession. Additionally, although I am an attorney, I share the Honourable Dean Smuts' concerns that the advocate's profession will now become the junior partner in the statutory arrangement, and in effect the advocates have been sold down the tubes. No one can deny that there is a fundamental difference between the attorneys and advocates' professions. That is why we argued for separate chambers for attorneys and advocates at a national level. Regrettably, this was not agreed upon. Clearly, we have, as the Honourable Smuts has pointed out, fusion by stealth. Whilst the ACDP's fallback position of separate chambers at provincial level was agreed to a certain degree, we still support the separate chambers at national and regional level. Now, the ANC has argued that to agree to that position would be to retain the status quo. Clearly, we in the ACDP respectfully disagree. These separate chambers would still be subject to the directives of the Legal Practice Council. There is no situation that it is business as usual. The status quo is different and changed. The ACDP also objected to the lack of parity on the Legal Practice Council. The Interim National Forum has equal number of advocates and attorneys represented. We don't understand why this parity was not extended to the Legal Practice Council. Again, the advocates have been sold down the tubes.
Your time have expired.
Thank you, Chairperson. The ACDP will not support this bill. I thank you.
Honourable Mtsheko.
Honourable Deputy Speaker, Deputy President and honourable members, we are now en route to the decolonization and Africanization of the South African legal system and the judiciary. This was long overdue. We must rid our legal system of racism, wealth and privilege as criteria for access to justice and legal services by allowing unfettered self-regulation of the legal profession and a deeply divided bar that escalates fees and make them inaccessible and make justice inaccessible to the majority of the people. A legal system must also be informed by the people's value system. It cannot be explained why today, 20 years after freedom, we still have to go to Roman Dutch law and English law to find out what is in the best interest of our people's aspiration for justice. We believe that the concept of Ubuntu, which transcends race, color, and creed, is enough to provide a basis for a South African and African common law. It is a matter of grave concern that on the eve of the 20th anniversary of our freedom from apartheid colonialism, political parties in this House are not yet at one on the transformation of the judiciary and the legal profession. The Democratic Alliance and some sections of the bar and sidebar do not even accept the term transformation. They want to change the form, not the substance of the legal system and the legal profession. Thus, they prefer the term restructuring, not transformation. The ANC made many compromises in good faith to enable the parties to reach consensus so that this Parliament can pass this bill. These compromises notwithstanding, the Democratic Alliance rejected this bill in its entirety, showing that they negotiated in bad faith. However, the ANC remains committed to this bill because it provides a framework for the transformation of the legal profession and the judiciary in line with our Constitution. The Legal Practice Bill gives the Minister of Justice and the unified legal profession the authority to drive the transformation of the legal profession, which is a prerequisite for the transformation of the judiciary itself. This will open the door for the Africanization or indigenization of the law. Ubuntu values and principles must be infused in our legal system to ensure that once and for all we eradicate the dispensation of justice on the basis of race, color, or creed. The DA and its supporters lose sight of the fact that the state has a primary responsibility to ensure that all citizens, regardless of race, class, and gender, have access to justice and legal services. The legal profession represents its self-interest, not the interest of the downtrodden who want to receive their due. The state is the custodian of the interests of the citizenry, not the legal profession. The independence of the profession is an important element of the rule of law, but it cannot and should not take precedence over access to justice and legal services. It must also be the responsibility of the attorneys and advocates to train a new crop of lawyers. And therefore, it is difficult to understand why the DA and its fellow travelers would argue that people serving pupillage should not be paid by the advocates, which means that the majority of young black graduates will not be able to enter the profession and therefore swell the ranks of those who must be appointed judges in this country. And therefore, we will remain with a white judiciary and white bar for many years to come. The DA sought to import lock, stock, and barrel an Australian legal fee structure in total disregard to the fact that in South Africa we have two worlds, the first and the third world. The DA lives in the first world and legislates for the elites. It has no regard for the overwhelming majority of the people who have not tasted freedom since 1652. South Africa and Africa must indigenize the law. In essence, the DA wants a system of co-governance between the executive and the legal profession that has not yet been transformed. Under apartheid colonialism, the criteria for access to justice and legal services was race and wealth. Under the DA government, it would be wealth and privilege. This would bar thousands of black graduates, in particular, from entering into the legal profession. The policy of the DA on the legal profession shows that the DA falsely makes itself a champion of job creation for the youth. Thousands of law students and graduates will soon see through the DA and respond appropriately. The DA has proven beyond reasonable doubt that its old-fashioned liberalism is a great impediment to its own transformation to include the black middle class. The DA is pro-corporate and is hell-bent on defending the social and economic privileges of the few. South Africans, especially the youth, would be naive to believe that a party that cannot transform itself would be able to transform the legal profession, the judiciary, and the country. So I can assure you, Mrs. Dean Smuts, that when we return in 2014 with an increased majority, we will transform the legal profession and ensure that we have a progressive legal profession. I hope that you will have retired that time, because otherwise you will be faint. Thank you very much.
Honorable Mfundisi.
Deputy Speaker, the Deputy President, and honorable members, I'm not a member sitting on the Justice Committee. Me fela ya ka motho go lentse go magaeng. Go fitlhela go buiwa kgomo ntsha thipa gago, lo ena o bo bua. Concrete steps towards a transformed legal profession are long overdue. As such, the necessity of this bill cannot be overemphasized. The instructive tone in the bill is understandable as well, even though understandable does not really translate into being correct or right. If the status quo is to continue, we are likely to take a century before we see substantial transformation in the legal profession, and we cannot allow this to go on. We welcome the leveling of the playing field in the legal playground, which we have no doubt that it will make all to feel their South African-ness. There is a mechanism in place should the minister lose confidence in the ability of the council to perform its functions effectively and efficiently. In line with due process, there are steps to follow and observe, and even involve the Ombudsman to investigate the made recommendations. Should the minister still have a lump in his throat, he will be at liberty to approach the High Court, and should the court give him the benefit of the doubt, only then may the minister appoint an interim council within 21 days of dissolution, whose tenure may not exceed 6 months. As the late former Chief Justice Arthur Chaskelson commented when the bill was introduced, it would serve all concerned and affected well if there were to be a concerted effort towards reaching a consensus in these matters instead of dictating what must be done. The Republic, being a unitary state, has to ensure that justice is meted out evenly. That the legal profession is not representative of the demographics of South Africa cannot be denied. And so there is need to ameliorate and regulate the different laws which apply in different parts of this country. We note and appreciate that this bill strives to ensure that access to legal services should not be the privilege of the high and the mighty only. The poor also have a right to be heard without compromising the independence of the legal profession. The UCDP hopes that this is one step towards ensuring that the third arm of the state, the Office of the Chief Justice, will sooner than later be afforded the opportunity to handle their budget as is the case with the Electoral Commission. The UCDP supports the practice bill.
Thank you, Honourable Member. Honourable Olomisa.
Now we know who in this parliament support transformation to the full extent of the term, and those who support it only if it maintains the status quo. Honorable Deputy Speaker, Honorable Deputy President, Ministers, Inkosi eziphakathi kwethu, Honorable Members, I join those who spoke before me in support of the Legal Practice Bill. This is a bill that seeks to transform the attorneys and advocates' professions with a view to help them promote access to justice by the people of our land, whilst at the same time promoting the interests of the practitioners. It goes without saying that the profession of legal practitioners is a vital cog in the machinery responsible for the administration of justice. These are people who are trained in the knowledge of the law in order to interpret it for the benefit of ordinary citizens. It should be self-evident, therefore, that our legal practitioners must be independent in the manner in which they carry out their vocation. It is in line with this basic principle that the Legal Practice Council will be composed of 10 practicing attorneys, 6 practicing advocates, 2 teachers of law, 1 person designated by Legal Aid South Africa, 1 person who need not be a legal practitioner, but designated by the Legal Practitioners Fidelity Fund Board, as well as a mere 3 persons designated by the Minister of Justice and Constitutional Development. So out of a council of 23 members, 20 are designated by members of the profession themselves. The passage of this bill by Parliament has long been in the making. As is the nature of transformation, a great deal of resistance and divisions from and within the profession were responsible for such delay. The legal profession is divided between attorneys and advocates, as well as along racial and gender lines. As in most professions and careers, whose origins come from our colonial and apartheid past, the profession is dominated by white males, much more so my profession, the advocate's profession. In our quest for an egalitarian, non-sexist, and non-racial society, it is imperative that this particular profession is assisted to undergo the changes necessary for the attainment of this goal. Clearly, those who benefit from the status quo cannot be expected to voluntarily effect the required changes. It would be naive and unfair of us to have such expectations of the beneficiaries of the current state of affairs. The structures that this bill will establish will ensure that the profession is independent, is professional, is racially and gender diverse, is accountable and accessible to the public it serves through, among others, a fair determination of the fees charged. It is imperative that all those principles are met without anyone being elevated above the others. Alongside all other bodies established by the bill, namely the Legal Services Ombudsman, the Board of Control for the Fidelity Fund, and the National Forum on the Legal Profession, the South African Legal Practice Council, and its provincial bodies will ensure that the legal profession is the service provider of choice for all South Africans, not just for those who have access to unlimited financial resources. In the event that the Legal Practice Council fails to function effectively and efficiently, as a result of which it loses the confidence of the Minister of Justice and Constitutional Development, the bill facilitates the dissolution of the council by the minister. Such power, contrary to what we have been told, to dissolve the council is subject to an elaborate process involving the consultation of the council by the minister, the requesting of the ombudsman to conduct an investigation, and ultimately an application to the High Court for the requisite order. Some of us in the committee would have preferred that, as part of the transformation, and especially with regard to the high fees charged to those who seek the services of lawyers, the attorneys and advocates professions be merged. After all, attorneys and advocates serve the same constituency. There can be no doubt that the benefits accruing from this division are enjoyed more by the practitioners than by the clients who pay for the services. For one case alone, a single client could be required to pay fees that are due to an attorney, as well as those that are due to an advocate. Sometimes there will be a junior and a senior advocate. Whilst in the course of our interaction with the attorneys and the advocates, the attorneys were amenable, some of them, to the idea of a merger. The bulk of the advocates were not so keen. In the interest of peace and the need to move forward, we have agreed for the time being to let the status quo remain. We also took note of the fact that a large body of advocates takes briefs directly from clients without the medium of attorneys. The bill provides that they continue to do so, provided that they are first issued with Fidelity Fund certificates, as is the case with practicing attorneys, in order to protect the interests of clients. Such an arrangement will contribute in some small way towards the reduction of legal costs. Historically and traditionally, judges of the High Court were selected from the ranks of senior advocates. Transformation and democratic imperatives demanded that there be a departure from this approach. As a result, our current judges, who are proving themselves to be quite capable of discharging their responsibilities, come from the ranks of advocates, junior and senior, attorneys, and teachers of law. The lawyers that our universities produce study for the same LLB degree. The junior degrees of BUris and BProc, which were required mostly for prosecutors, magistrates, and attorneys, are no longer offered. All are now required to have the same LLB degree. The justification, therefore, for the continuation of the division between attorneys and advocates is gradually fading. There shall therefore come a time when Parliament shall have to amend this law to accommodate this reality. We are legislating for success. The ANC, as has been said, fully supports the passage of this bill.
Thank you, Honorable Oromisa. Honorable Deputy Minister of Justice and Constitutional Development.
Thank you, Madam Speaker. Deputy Speaker. Madam Deputy Speaker, it's a pity this debate comes so close to an election because it seems that a number of parties are electioneering in this House. But basically, I'm quite surprised with some of the comments made that the bill is going to interfere with the independence of the profession. It's going to take over allow government to control the judiciary and so on. And I really think that anyone who has those arguments with respect either hasn't read this version of the bill before the House or has been smoking their socks. Basically, as far as government or ministerial control over the council, 3 people out of 22. That's all. The rest are appointed by the different constituent parts. The disillusionment of the council, which was raised as another example of ministerial control, that's been dealt with by Mr. Mfundisi and Nkosi Holomisa. The issue of the minister making regulations, those regulations are subject to approval by Parliament. So really, I think it is absurd to claim that this bill will enable government to control the legal profession. The main issue is really the question of convergence. Now, for those non-lawyers, the British Commonwealth, former British Commonwealth countries have attorneys and advocates or solicitors and barristers. And the issue is about their separation. And it's been alleged that this bill is fusion by stealth. It's not fusion by stealth. You still have advocates, they still have their own training, that's after they get the same law degree as attorneys. They still have their own representation on the council. But you have had advocates and attorneys doing more of the same work. So in 1995, attorneys got the right to appear in the high courts, which only advocates could appear before. This bill does bring it a little bit closer with allowing advocates to take direct briefs. So the work is overlapping more and more. Why must you then have 2 separate codes or separate disciplinary processes? An advocate appears in the High Court, messes up the case. Why must they be dealt with differently to an attorney who does the same? And what is interesting is that in a number of Commonwealth countries, on this continent, some of them were mentioned, but Nigeria, Kenya, Zimbabwe, Namibia, on independence, the distinction between attorneys and advocates was abolished. Now, I know for the DA, those are only African countries, so you don't really regard them that highly. But that also applies to New Zealand, which I know you regard more highly, and Australia. So what is the big issue? I want to quote from the president of the UK Law Society. The new modes of practice will increasingly challenge the norms under which lawyers practice under the separate titles of barrister and solicitor. I believe this development will lead inevitably to the need to revisit the question of whether these 2 professions should continue to be trained separately, represented and regulated as they have been over the past 180 years. I envisage the time coming when the barrister-solicitor distinction will be more a decorative than a functional aspect of our legal constitution. So that is from England, the country you regard very highly. Now, The issue basically is it doesn't surprise me that the DA has this position on this bill because the DA represents conservative established interests and their opposition to the legal practice bill is just an indication, another indication of that. But Madam Speaker, I think that a lot of work has been put into this bill, if the DA members can listen and not just barrack. A lot of work has been put into the bill. I think we have produced a very good bill, and I think that it will finally 3 senior counsel. Only 4 of them are African women. And just one thing on the parity of what things were like in the constitutional negotiation, but basically the AA.
I now put the question. Those in favor will say aye. And those against will say...
Alliance calls for a division.
A division having been called, the bells will be rung for 5 minutes. Uyaphi? Seyizawuvalile. Seyizawuvalile. Order. I would like to remind members that they may only vote from their allocated seats. When requested to do so, members must simply indicate their vote by pressing the appropriate button. If a member presses the wrong button, the member may thereafter press the correct button. The last button pressed will be recorded as the member's vote when the voting session is closed. The question before the House is that the legal practice bill be read a second time. Are all members in their allocated seats? Voting will now start. Those in favor of the bill being read a second time should press yes button. Those against should press no button. Those wishing to abstain should press abstain button. Have all members voted? Thank you. The voting session is now closed. This one. Order. The result of the division is as follows. Ayes 227, noes 81, abstention 1. The question is accordingly agreed to, and the Secretary will read the bill a second time.
Legal Practice Bill.
The bill will be sent to National Council of Provinces for concurrence. The Secretary will read the 19th order.
Consideration of legislative proposal, namely Judicial Matters Third Amendment Bill submitted by Portfolio Committee on Justice and Constitutional Development.
Honorable Landers.
Deputy Speaker, the Portfolio Committee on Justice and Constitutional Development considered the Judicial Matters Amendment Bill, which was tabled as a proposed Section 75, but was subsequently tagged a Section 76 bill by the joint tagging mechanism on the basis that it contains certain provisions that affect the concurrent powers of provinces set out in Schedule 4 of our Constitution. In order to expedite the passage of those provisions of the bill to which Section 76 procedure would not apply, the committee rejected clauses 17, 36, 39, 42, 43, 46, and 49 subsection 3, which were argued would possibly affect the concurrent powers of the provinces in a substantial measure. The committee resolved to initiate a separate bill focusing solely on these clauses. The purpose of the Judicial Matters Third Amendment Bill is to amend Section 78 of the Attorneys Act, which in the Judicial Matters Amendment Bill was Clause 17. The bill further seeks to amend certain provisions of the Child Justice Act, which in the Judicial Matters Amendment Bill were clauses 36, 39, 42, 43, and 46. The committee has already received public inputs and deliberated on these clauses as they were part of the Judicial Matters Amendment Bill that I have referred to. There is therefore no need for the bill to be published in the Government Gazette for public comments. And therefore we stand before this House seeking its permission to initiate a Judicial Matters Third Amendment Bill as a matter of urgency. Thank you.
Thank you, Honorable Landers. I now recognize the Honorable Chief Whip of the Majority Party.
Honorable Speaker, I move that the House, in terms of Rule 238, subsection 3, give permission to the legislative process to be proceeded with.
The motion is that permission be given to the Portfolio Committee on Justice and Constitutional Development to proceed with the legislative proposals. Are there any objections? No objections. Agreed to. The Secretary will read the 20th order.
Consideration of Protection of State Information Bill, Report of Ad hoc Committee on Protection of State Information Bill thereon, and the President's reservations on constitutionality of bill as submitted to him.
Honorable members, I've been informed that the report of the Ad hoc Committee is published on page 5791 of the announcements, tablings, and committee reports dated 11th November. Honorable Minister of State Security. Honorable members, whilst Minister is coming to the podium, the level of noise is very high. I know most of you might be excited about tomorrow being the last day. I'm not sure there's a kind of excitement. It disturbs me, I can't hear properly. Please, can your level be lower? If you're planning a surprise for tomorrow, can you maybe plan that surprise on the second floor or somewhere else so that those of us who want to listen, we can still listen, please. Honorable Minister.
Honorable Deputy Speaker, Honorable Deputy President, members, the ANC welcomes the President's referral of the Protection of State Information Bill to the National Assembly for consideration of his reservation in terms of Section 79(1) of the Constitution, because sections of the bill, in particular 42 and 5, lacks meaning, coherence, consequently being irrational and accordingly unconstitutional. We are happy that the committee agreed with the President's reservation and corrected them comprehensively as reported in the committee report before the Assembly. What is clear, Honorable Deputy Speaker, what caused the problem, first of all? What caused the challenge identified by His Excellency President Zuma are several technical errors in the final bill which was sent to him, some of which were so material that they could be challenged by members of the public to whom they were imposing obligations which were incoherent and irrational, as in sections 42 and 45, in that they were creating offenses or sometimes putting obligation to return classified documents. We thank the President for putting the people first in bringing back this reservation. We thank the committee for dealing with other technical errors in the bill, even if they were not so material, but had the potential of being incoherent and irrational. For instance, incorrect spellings, punctuations, and incorrect cross-references. What is clear, Deputy Speaker, is that Parliament must seriously increase its capacity to avoid technical errors in legislation, as Parliament is now unlike during the apartheid era, dealing with large volumes of legislation. We must increase the capacity of Parliament's legal and drafting and committee sessions in order to provide appropriate support to Parliament and its committees when making amendments. The ANC supports the bill. Thank you.
Thank you, Honorable Minister. Honorable Burgess.
Honourable Deputy Speaker, Honourable Deputy President, Honourable Ministers, Honourable Members, allow me quickly to remind the House of the history and the road of the bill has followed in respect of this matter. On Thursday, the 12th of September 2013, the ACT published a letter the Honourable Speaker received from the President returning the Protection of State Information Bill to the National Assembly for consideration of the President's reservations about its constitutionality. The referral of the President was made in terms of Section 79(1) of the Constitution. On the same day, the House met and by resolution established an ad hoc committee to consider and report on the President's reservations and the bill in terms of Joint Rule 203 and to report to the House by the 31st of October. The procedure set out in Rule 203 provides that the committee must consider and confine itself to the President's reservations. The rule further provides for conferring with the corresponding NCOP committee in certain specific circumstances. The ad hoc committee met on the 9th and the 10th of October 2013 to consider the reservations of the President. In this regard, the committee considered Section 79 of the Constitution, which provides for the President to refer a bill back to the National Assembly if he has reservations about the constitutionality of the bill. The committee also considered the provisions of Joint Rule 203. In addition, the committee was briefed on the present Constitutional Court precedents that deal with Section 9 referrals. Honourable Deputy Speaker, after much deliberation, the committee came to the following conclusions. The referral of the President was specific and related only to the constitutionality of clauses 42 and 45 of the bill. It was not necessary to confer with the corresponding NCOP committee because of the substance of the referral. And the bill contained certain typographical and grammatical errors which needed attention. The committee then considered clauses 42 and 45. There was an incorrect cross-reference in clause 42, where the clause referred to section 15. It should have referred and read section 13. The structure of clause 45 of the bill needed to be rearranged in order to make it rational. Accordingly, by majority vote, the committee agreed to amend clauses 42 and 45, and the amended clauses have been published for the consideration of the House. The committee also, by majority vote, agreed to refer to the identified typographical and grammatical errors to the House for consideration. The committee completed its work on the 10th of October, and the committee report was referred to the House and was published in the ATC on the 15th of October. On the 22nd of October, the House, by resolution, referred the matter back to the committee to further consider its report on the bill. The deadline to report was extended to the 7th of November. The committee met on the 29th of October and agreed to amend the report to include the minority views of the DA and the ACDP. COPE and IFP were absent from the meeting. The State Law Advisor was requested to peruse the entire bill to check for any other typographical and grammatical errors. The committee then met on the 30th of October and by majority vote amended the committee report, which contained all the minority views, was adopted for referral to the House for consideration. The committee also by majority vote agreed to submit to the House an amended list of typographical and grammatical errors for consideration, which had been identified by the State Law Advisor. However, the House again resolved on the 7th of November to refer the report back to the committee for further consideration, and the deadline for the committee to report was extended to the 12th of November. The committee met on Friday, the 8th of November, and by majority vote, the committee report was amended to include the reference to the textual and technical errors I have already referred to, and the Minister. I might add that the majority view was that these corrections are in line with the need to ensure that the bill is coherent and rational. Honourable Deputy Speaker, in the circumstances, the committee have considered the reservations of the President in respect of clauses 42 and 45, recommends to the House that the President's reservations be accommodated and accordingly reports the bill with amendments. The committee also considered the provisions of Joint Rule 203 and reports that it is not necessary for the bill to be referred to the corresponding NCOP committee, since the reservations of the President do not relate to matters which fall within the ambit of Sub-Rule 203, Subsection 2, Roman 1 and Roman 2. Honourable Deputy Speaker, you've heard some noises here to my left, and I have previously warned the House that the Protection of State Information Bill has the tendency to seriously affect the behaviour of reasonable people. They start to behave incoherently. They say funny things. The House will soon observe the transformation on my left that debate will create. You hear now, Speaker. There it starts. Honourable Deputy Speaker, you wanted to know what's happening, why people are so uncomfortable. It's not because tomorrow's the last day, it's because of the information bill that's in the House today. Honourable Deputy Speaker, the ANC comrades in the committee are clear and not confused. They understand the need for the bill. They have worked with distinction while dealing with the reservations of the President. Their attendance in meeting was excellent. Allow me, therefore, Deputy Speaker, to thank all those who assisted in the work, especially my ANC comrades. Also the Minister of State Security, who visited our meetings and was welcome as a guest. The Parliamentary Legal Services and the Office of the Chief State Law Advisor, and all the honourable members of the opposition, even those that grumbled and stumbled and disagreed just for the sake of disagreeing. The typical opposition stance, we must not agree with the ANC even if they are right. The ANC supports the amendments. The ANC supports the report, and the report is accordingly presented to the House for consideration and adoption. Thank you.
Thank you, Honourable Burgess. Honourable Leader of the Opposition.
Thank you, Honourable Deputy Speaker, Honourable Members. 2 years ago, on that now infamous Black Tuesday, this House sent a message to South Africa that the freedoms won by those who came before us can never be taken for granted. In a glaring assault on our Constitution, the ANC, dressed in the brightest colours and with iron-fisted determination, pushed through a bill that would kill transparency, boost corruption, and fundamentally undermine freedom of expression. It was a defining point in our democracy. We could either sit idly by while our freedoms were undermined, or we could fight in defence of our Constitution. If ever we were unsure whether our democracy could sustain an attack of this magnitude from the governing party, our collective message was clear. Outside the gates of Parliament, a coalition of civil society movements, the media, and South African citizens were unrelenting in bringing pressure to bear on Parliament to ensure that this bill be brought in line with the Constitution. Inside this House, members from the opposition, including the Honourable Dean Smuts, the Honourable David Mania, the Honourable Mario Ambrosini, and the Honourable Steve Swart, refused to back down in the face of this assault. They fought day in and day out to roll back the worst of this bill. And in the NCOP, the Honourable Alf Lees and the Honourable Darrell Worth kept the pressure up. It was a coalition in defence of our Constitution. It was a coalition that South Africans will look back in our history books on and honour. But, Madam Deputy Speaker, our fight did not end there. While our efforts changed some of the worst aspects of the bill, the Protection of State Information Bill that was passed this year remained inconsistent with the Constitution. The definition of national security remained too broad. This means that the state could still infringe on people's right to access information and undermine the constitutionally enshrined principle of freedom of expression. The bill still dealt with a category of information which had nothing to do with security or classification, called valuable information. This allows the State Security Minister to make regulations with respect to what is ordinary government record keeping. This, in our view, is an attempt to perpetuate the minimum information security standard system, which is currently only cabinet policy. And fundamentally, the bill legislated on what is the provincial government competence of provincial archives. We therefore maintain that it should have been tagged as a Section 76 bill and not as a Section 75. It is for this reason that following the National Assembly vote on the bill, I petitioned the President in terms of Section 79 of the Constitution to refer the bill back to Parliament, so that these problems could for once and for all be corrected. Confronted with these genuine substantive concerns, and ahead of an election campaign in which his party is already on the back foot, the Honourable President could not simply sign this bill into law, not without at least seeming to care about its constitutionality. Because when he referred back this bill to the House, he appears to have done so only to address technical and grammatical problems relating to sections 42 and 45 of the bill. No reference was made to the broad definition of national security, no reference to valuable information, and no reference to the incorrect tagging. Let me be very clear, honourable members. The DA fully supports correcting these technical anomalies. It is a shame that the bill was passed with them in the first place. But there is much more that needs to be fixed. And the Honourable President knows this because we submitted legal opinions to him which detailed these problems in meticulous detail. Perhaps this is the reason that, despite established precedent by the former President Thabo Mbeki and former President Motlanthe, whose referrals were detailed and clear, President Zuma's referral was vague. Perhaps this is also why the Honourable President did not respond to my letter requesting that he clarify the terms of his referral, or to my second letter following up on the first. And perhaps this is why the ANC in the ad hoc committee refused the Honourable Smuts' request that the ad hoc committee seek clarity on the referral from the Honourable President. Madam Deputy Speaker, the DA will not give up fighting on this bill. We will not stop until it is brought completely in line with the Constitution. We are not fooled by the public relations tactics of the presidency. And the ANC should be ashamed for thinking that South Africans will fall for these tactics. This is why I will again petition the President in terms of Section 79 of the Constitution. This bill must come back to Parliament, and the real substantive problems with it must be addressed. If that does not happen, this bill will unavoidably end up in the Constitutional Court, and this House and every member who supported this bill will be left ashamed. Because, honourable members, a government which supports an apartheid-era National Key Points Act, which goes to court to prevent investigative reports into Nkandla from being released by the public protector, which classifies public documents regardless of the public interest, cannot be given even more power to put secrecy above transparency. And because, Madam Deputy Speaker, a security cluster under President Zuma, which is unrelenting in its efforts to advance the cause of secrecy, from Gupta Gate to Nkandla Gate, from spy tapes to the proposed appointment of Robert McBride as the head of IPID, from Marikana to the arms deal, A security cluster of this kind should not be given more power to avoid accountability. Honourable Deputy Speaker, over the last 2 years, our coalition in defence of the Constitution has held strong. We must now finish what we set out to achieve, a fully constitutional protection of state information bill, and we must accept nothing less. I thank you.
The next speaker is the Honourable Khanare.
Honourable Chairperson, Honourable Deputy President, Honourable Ministers and Deputy Ministers. As stated in the committee, COPE does not go along with the charade which we went through after the letter from the President was presented to this ad hoc committee. The fact that the ANC wanted the committee to limit the discussions to only Section 42 and 45 as per what their interpretation of the letter from the President states, and immediately suggests that we amend other clauses which reasonably have to be amended due to grammar, punctuation, and spelling. The Honourable Burgess stated the history of this particular committee as if everything was going smooth. The truth is, the ANC tried to bulldoze everybody in this particular committee all the time. That's why the report had to be sent back by the Speaker to the committee to correct what they were told should be corrected. Their refusal to include the minority views in the report. It actually clearly states about the attitude of the ANC towards anything. They believe that the majority, even if it's wrong, must continue to bulldoze everybody. It's really unfortunate that, Honourable Speaker, the letter from the President raises concerns about the constitutionality and taking of the bill. On the other hand, the proposed amendments of Section 42 and 45 deals with the crossing of the T's and the dotting of the I's. We don't believe that the non-crossing of the T's and the non-dotting of the I's can on their own render the bill to be not to pass the constitutional muster. COPE believes that since Section 42 and 45 are referred to by the President as examples due to the use of the phrase in particular, on what lacks meaning and coherence, the logical thing the committee should do was to ask for more clarity from the President. The committee's task was limited to only deal with the clauses referred to by the President. No reasonable legislature can ignore correcting obvious spelling mistakes, hence COPE supported the other technical amendments which were not referred to by the President. It is interesting, Honourable Chairperson, that the ANC did not support the proposal to look at the bill as a whole, because to them, the President was specific about dealing with Section 42 and 45. But when it came to other clauses which had errors and all that, they then used a different logic and said we must deal with that because we can't allow the bill to go through with such mistakes, which was reasonable. But their logic is very problematic, that when it comes to the other point, the President did not specify, but when it comes to what the President did not specify, if it suits them, it must be dealt with because it's logical. That's a very difficult logic from the ANC. It's particularly because the ANC knows that this law is wrong. They know that this bill is wrong. They know that this bill, if it was law today, the charade which we are seeing in our courts about the public protector and the Minister of Justice would not see the light of day because they would have used this law to try and block the public protector from doing her job. COPE believes that the letter of the President gave us an opportunity to review the bill as a whole, but the ANC used its numbers to bulldoze all other parties. That's why it's important for voters to understand that not voting will only strengthen the dictatorship of the ANC. Honourable Speaker, the drama involving Kantla report, as I've stated, indicates very clearly the operation of the ANC, which is going to be bringing police state by stealth. I thank you.
The next speaker is the Honourable Ambrosini.
Thank you, Mr. Chairman. What are we doing here? For the third time in a row, we are adopting a bill which we know to be unconstitutional, which we know to be unpopular, which we know to be retrograde to the will of the people of South Africa and all the building block of our society. Why are we doing it? It's a recurring question which has yet to be answered. It is not within the tradition of the ANC. It is not within the tradition of the liberation movement. It is not in the tradition of the IFP, or the Democratic Party, or the United Front. This bill is only within the political tradition of that which no longer exists, which is the National Party. We are reenacting a page that only the National Party could have written. And it is retrograde to the political tradition of all the parties which have now brought this country into democracy and are trying to build a new constitutional order. That is what we are doing. And how are we going about doing it? In the most surreptitious way. It is before you have a report which in a relevant part states, I no longer have the energy I used to have. The committee further decided that it was unable to agree to the inclusion in the report of a letter by the IFP, which actually misrepresented events of the proceedings and positions taken by the members
Honourable
of the committee.
members, the noise is too high. I can't hear the Honourable member.
Let me speak. Now,
order, Honourable members.
There was no such a thing as a letter. There was a one statement that we were trying to put in the minority report. One single line. And in the report approved by the committee, it was nothing more than a line. They had to reconvene once more to turn that into a lie. The report originally said that they would not publish what we wanted because they would not agree with it. They would not agree with our view, and therefore they censored it. And what was the view? The view was, and I read from what I submitted to the Honourable Burgess, shame on you, Honourable Burgess. I submitted the committee should have considered the problems of constitutionality of the bill identified in the opinion of Advocate Anton Katz.
Order, Honourable members.
We wanted the real issues to be considered, not the grammatical issues. The President was seized with two documents, a serious opinion of constitutionality raised by the leader of the opposition on behalf of the entire opposition, and a number of, sorry, Honourable Smart.
Address
Well,
the chair,
I think you should
member.
start speaking for the DA. You were the one who opposed the
Honourable
tabling,
Ambrosini,
who
will you
opposed the
address the
tabling of
chair
your
and
own
not the
leaders
member?
or later. And I've got here the transcript. You, Honourable Smart, you might
Honourable
misrepresent
Ambrosini.
when you call me. Sorry.
Address the chair and not the member.
Okay, Mr.
please.
Chairman, the Honourable Smart was in terrible error when she called me a liar in the committee because she was napping when I requested that the opinion of Advocate Katz be tabled in the committee and considered. I've got the transcript here that I will very glad share with her. All that we wanted was merely that the committee utilizes the power that it has under the Constitution to review the entire bill and address the real issues. We believe that the President was aware of this power and sent it back for issues of grammar in the hope that we would address
Honourable member,
the
your
real
time is
issues of
expired.
constitutionality. Thank you, Mr. Chairman. Many doctors told me that, but I'm still alive. Thank you.
Thank you, Honourable member. The next speaker is the Honourable Sitole.
Water. Honourable House Chairperson, Honorable Deputy President, Honorable Ministers, and Honorable Members of Parliament. I want to greet members of the African National Congress, the people who are governing this country today, and the people who will win the election in the coming elections. Because after all what has been said here, the people were listening. And I'm convinced they are not going to vote for any of the people who spoke here. The President was very clear, crystal clear, on what he wanted us to do. It was to deal with clause. On the other issues, people are not aware, the opposition is not aware that we are not the only Australia, in New Zealand, a banana republic. We are a sovereign state of the respect that we want to protect the safety of the citizens of this country. That is for you because you are only half of you will not come back here. The leader of the opposition, unfortunately, was not in the committee. She is not aware that Honorable Ambrosini and Honorable Smarts were not agreeing. And I see he was complimenting, putting them together as if they agreed. They never agreed. So it's a pity if we are, as the ANC, going to protect part of what we do well because you are sick. But even if people heard what Ambrosini, I don't know what he is raising it again here. So, signed the bill. He went through the bill. He will still be chosen by the people of South Africa. I thank you.
True. It seems that in places of society, transformation has become a tool whereby all diversity and people known as the secrecy bill then has a fitting place within this great freedom of expression and information. So now, with the coming to power of the ANC, 1994 has become our very own 1984. Die feit dat die wetsontwerp soveel keer gepaneelklop moes word vanweer die oppositie se kommer, is juis getuienis dat die ANC en hierdie onskuldigste van bedoelings hiermee gehad het nie. While many changes to this bill has been effected due to the hard work of fellow opposition MPs, we are still resolutely opposed to the passing of this bill. The future does not have to be like the past or the present. It can be better. One thing is certain though, we still have to continue to fight for our freedom against this onslaught of the ANC in the future. Thank you, Speaker.
Thank you, Honourable Member. The next speaker is the Honourable Swart.
Thank you, Chairperson. On the 25th of April this year, when we debated this bill following the NCOP's welcome amendments, I, on behalf of the ACDP, said, we believe that the all-important Section 45 relating to the purported offence of improper classification does not disclose an offence as presently formulated, and I suggested that the words "is guilty of an offence" should be inserted into the Section 45 after the word "process." I indicated that the ACDP would be petitioning the State President on this and other issues, and myself and the Honourable Dean Smuts then drafted a petition including these concerns as well as tagging concerns and the incorrect reference number in clause 42. And as you know, the President Zuma referred the bill back to Parliament on these two very issues that we raised with him. Now, the effect of the amendment to Section 45 is that journalists and whistleblowers who possess or disclose improperly classified information, where such possession or disclosure shows criminal activity, including improperly classifying documents to hide corrupt activities, will no longer be guilty of an offence. This, the ACDP, made very certain that when we proposed the amendment, it was inserted, and we support this correction as it goes to the very important improper classification that myself and Honourable Dean Smuts had requested. We were concerned, and many people in the public are concerned, that the bill will be used to hide corrupt activities. And without this amendment, it would have gone to the heart of the bill. And that is the reason why we supported this proposal when it came back to the committee. However, the reason why we as the ACDP abstained from voting is the larger issue of the referral under Section 79 of the Constitution. Now, the Constitutional Court made it very clear in the liquor bill matter that, quote, Section 79 clearly envisages that the President's reservations must be specified when he refers the bill back to Parliament. Now, the court also said that this requirement negatives the notion that a court's function is to determine once and for whether a bill accords in its entirety with the Constitution. This makes eminent sense, and the President's Section 79 referral must be specific. This was the case with previous referrals where exact arguments were given and exact clause references were given. However, in this case, it is very clear that it was a vague referral. Now, we cannot, as Parliament, act on vague referrals without the risk, as the Honourable Smuts said, of creating a precedent where a President does not like a bill, he refers it back with vague specifications. He has to assent except where he has specific constitutional reservations. All we in the committee asked for was clarity from the President. It was unclear. This was refused by the committee, placing us in the ACDP in the dilemma that what we had requested was approved to a certain degree, but our concerns related to the process. And for that reason, whilst we welcome the amendments and we still believe that the matter should be referred to the Constitutional Court for its final approval, we are unable to support this bill, regrettably, today. Thank you.
The next speaker is the Honourable Make.
Thank you, Chairperson. What has been said here by the opposition is trying to open up the bill again, and they lost. It was very clear that the President wanted us to deal with two clauses, which is exactly what we did. I've never in my life heard of a country that is transparent even in secrets that are necessary for its survival. The bill has been called names. We were here, we were all listening. People who didn't get themselves to call the bill using its real name. It is called Information Bill. Some prefer to call it the Secrecy Bill. This being only to hoodwink our people into thinking that there's something secret about the bill. The real aim of the bill is to protect sensitive state information. And none of the opposition said exactly that. It is to provide protection for certain valuable state information against alteration, loss, or unlawful disclosure, and to regulate the manner in which state information may be protected. I've never heard any of them saying valuable state information. That is the name of the bill. Why don't they say it? In addition to the broad outlines provided above, the bill aims to strike a balance between the protection of state information and access to information. The bill, for example, states that, open quote, access to state information is a basic human right, close quotes, and that the free flow of state information promotes openness, responsiveness, informed debate, accountability, and good governance. And that is what the ANC is saying. None of the opposition is saying that. The key word in the whole bill is state information. Or may I say, sensitive state information. It is therefore very surprising that some people in this House are vehemently against this very reasonable bill. As I said earlier, in which country would sensitive information be given to the whole world in the name of openness? If we as a country had invented the most sophisticated missile, are we supposed to advertise it to the whole world, including our enemies? This wouldn't be openness. It wouldn't be accountability or good governance. But it would be stupidity of the last order. What do these people want who are in this house? What do they want to do with such information? Do they perhaps want to peddle it? All these laws, regulations, and policies were established by the ANC in order to make South Africa a better place to live in for all of us, not for a certain section of the population, which in any way were previously spoiled. Did this happen before 1994? If it didn't, then why do they want it to happen today? Some of them were in that parliament, but never raised a finger in this regard. There were only 2 areas in the bill that were referred back to parliament by the president. But the opposition wanted to open the whole bill for further discussion, only because they never had their way. As long as we, as the African National Congress, are still in power, they will never have their way. However much they moan, howl, and whinge, and in any way, they will never be in power until the chickens come to roost. Being in power is not bulldozing. It is what is called democracy in simple English. Thank you, Honorable Chairperson. The ANC definitely supports the amendment to the bill.
Thank you, Honorable Member.
Thank you, Chairperson. Chairperson, honorable members, Deputy President, we will not allow that as the ANC. The President's reservations on the bill that the President had fallen foul of the Constitution by failing to give MPs an exact brief is baffling. What brief did you expect from the President? We were saying in the comment, and that is why the President directed us to Section 42 and Section 4. Chairperson, in the committee, I hear people talking here. It's a pity that, Honorable Smarts, you were not the one who was talking here. Well, it's always the arrangement. With yourselves as a party, I know what happens there. If you look at what Cope has said here, it's confusing. That Cope member was a political tourist in the committee. He would come and never read a document without wearing glasses of the DA. Whenever he read a document, he would borrow glasses from the DA and read with the mind of the DA. That is why he said what he said here. They say the referral was vague, yet it's them that are saying in this podium, on this podium, they say that the President referred us to 42 and 45. I wonder how vague is that? He says, I don't even think you have read the letter, because you were never there when we read the letter as the committee. They were saying, Honorable Member Ambrosini was saying, in fact, it's not the first time that Honorable Ambrosini was opening a can of worms. Honorable Ambrosini said that this is an opportunity. This is an opportunity. Let's start from clause 1. That was not the brief. That was not the brief. And in that committee, I've never seen what I've saw in that committee. When lawyers were fighting about who's the best lawyer, when lawyers were not trusting their own intellectual capacities, they would rely on other opinions. I couldn't believe that. The fight was between Honorable Dean Smarts and Honorable Member Ambrosini. The other one was saying, there's a lawyer whose opinion as a committee we need to take. And the other one was saying, I brought that opinion. We had to listen to such things in that committee instead of dealing with what the president had referred to the committee. It's a pity Honorable Member Ambrosini is not well, because Honorable Member Speaker, he was writing letters complaining that he was not informed about meetings. I've got proof from this table and from the secretary that he was informed about meetings, and he couldn't go to meetings, perhaps because of his ill health. Oh, there he is. You were sent an SMS at 5:35 on the 7th. What is false? What is false? You were sent an SMS, and that SMS went to all of us. And all of us were discussing the bill according to the letter of the president. And for Honorable Member Steve to say the letter was vague, we discussed that and we said, Honorable Member, you can say as individuals that the letter was vague, but the letter pointed directly to two sections that we had to deal with. What is vague in that? What is vague in that? But on that, on se as the INCA, and the bill is going to go accordingly, and the opposition party, it's your work to oppose. It's your duty. You are paid to oppose us. Go on opposing. The ANC supports the bill. Thank you very much.
I now call upon the Honourable the Minister of State Security.
Thank you, Chairperson, House Chairperson. Let me start by thanking the committee for doing a superior work. But let me start maybe responding to Honorable Mazibuko, the leader of the opposition, and maybe assist her in her false allegations. The first one, she say, the referral did not deal, or we did not deal with substantive issue in the bill. For the last 3 years, Honorable Mazibuko, we have been dealing as this parliament with substantive issues of the bill. And we've made considerable progress in improving. As the ANC and the ministry, we've always said that we'll welcome all amendments which improve the bill in terms of its effectiveness and its constitutionality. The second allegation, you said the referral was just looking at technical errors. Let me help you by reading the letter from the president. The letter from the president, he said, I've given considerations to the bill in its entirety. It is entirety. And various opinions, not one opinion, various opinions and commentary regarding inter alia, the constitutionality and the tagging of the bill. So it didn't just consider one view or referral. After consideration of the bill and having applied my mind thereto, I am of the view that the bill as it stands does not pass constitutional muster. That's a letter from the president. The third false allegation of the referral being vague. The referral was not vague at all. It was self-explanatory. Let me read it for you. Yes, I read it. In terms of Section 79(1) of the Constitution, I hereby refer the attached bill to the National Assembly for consideration insofar as sections of the bill, in particular, let me finish. In particular, Section 42 and 45 lack meaning and coherence, consequently, are irrational and accordingly unconstitutional. What Honorable Mazibuko, as I've said, what was the basic problem? The basic problem was the capacity to correct technical mistakes. Some of them were very material. When we are intending to create a sentence and we are not actually creating a sentence. And one of those areas, it was areas where Parliament have expressed itself to say people who falsely classify documents for wrong reason other than this law must be punished. Now, if the law which we are passing as Parliament doesn't create an offense, it's material. Because Parliament felt very strongly about this. The other one is the possession of classified information, that we have got a responsibility to take it back. That's material. And that's why the President said, in particular, those sections needs to be specifically addressed. So, what the members say now, because of what I said earlier, the problem of capacity to deal with technical errors. He wants to have said now, President must say in page 1 there's a technical error 1, in page 2 there's a technical error. And that's what the leader of the opposition is trying to say. Honorable Ambrosini, let me thank you for your views. And despite the attack from the members of the opposition, but even if they are incorrect, because you've got views. But you are saying today the bill, there is no need for this bill. Basically, that's your argument. Let me remind you what caused us to bring this bill here. For the first time in this country, we are introducing a declassification system of classified information, which was never there, so that people, after a reasonable time, can have access to this information, so that those can know what happened in the past, and those who want to do research can do such research. We are saying we are protecting valuable information which is not classified. The leader of the opposition says it's not material, but it matters to a lot of people. Those who get their identification documents falsely changed, they are not classified, but it is in the hand of the state. The bill tells us that we must protect that information so that it shouldn't be interfered with. It means something to those who have got companies who are changed.
Honourable Minister, your time has expired.
In our presence. So as the ANC, we really support this bill and we move, Chairperson. Thank you.
Thank you, Honourable Minister. Honourable members, that concludes the debate. I now recognize the Chief Whip of the Majority Party.
House Chair, I move that the bill be passed.
The motion is that the bill be passed. Are there any objections? Yes. I now put the question. Those in favour will say aye. Aye. And those against, no. I think the ayes have it.
House Chairperson, the Democratic Alliance calls for a division.
A division having been called, the bells will be rung for 5 minutes. Honourable members, will you take up your seats? Order. I would like to remind members that they may only vote from their allocated seats. When requested to do so, members must simply indicate their vote by pressing the appropriate button. If a member inadvertently presses the wrong button, the member may thereafter press the correct button. The last button pressed will be recorded as the member's vote when the voting session is closed by the chairperson. The question before the House is that the Protection of State Information Bill be passed. Are all members in their allocated seats? Yes. Voting will now commence. Those in favour of the report being adopted and the bill being passed should press the yes button. Yes. Those against should press the no button. Those wishing to abstain should press the abstain button. Have all members voted? Thank you. The session is now closed. Honourable members, the result of the division is as follows. Those in favour 225, those against 88, and there's no abstentions. The question is accordingly agreed to and the bill will be sent to the President for assent. The Secretary will read the 21st order.
Consideration of report of Portfolio Committee on Water and Environmental Affairs on South African Weather Service Amendment Bill.
I now recognise the Honourable, the Chief Whip of the Majority Party.
Honourable Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objections. Agreed to. The Secretary will read the 22nd order.
Second reading debate, South African Weather Service Amendment Bill.
I now recognise the Honourable, the Minister of Water and Environmental Affairs.
Thank you very much, Honourable House Chair, Honourable Deputy President and colleagues in the House. I take this opportunity to once again commend the Portfolio Committee on Water and Environmental Affairs for finalizing the South African Weather Services Amendment Bill so quickly. Last week, Tuesday, when this House debated and adopted the National Environmental Management Air Quality Amendment Bill and the National Environmental Management Integrated Coastal Amendment Bill, I informed the August House that the Portfolio Committee on Water and Environmental Affairs has already processed 7 technical, very, very technical indeed, difficult and important bills for this environmental sector. One other bill is still in the process of being finalized, and that's NEMLA 3. The overall objective of these bills are to ensure that environmental right, as contained in Section 24 of our Constitution, is progressively realized for our people. Today, this House is debating and adopting the South African Weather Services Amendment Bill, and I therefore once again commend the Portfolio Committee on Water and Environmental Affairs for a job well done. The South African Weather Services Amendment Bill seeks to amend certain sections of the South African Weather Services Act 2001. The SOARS Act, as it is always called SOARS, was actually promulgated in the 2nd June 2001 and came into operation on the 15th of July 2001. The purpose of the Act is to establish the South African Weather Services as a juristic person and to determine its objectives, functions, and method of work.
Honourable Minister, just a moment, please. Honourable members, there's too much movement in the House. Will members take up their seats or leave the chamber, please? It's difficult to follow what the Honourable Minister is introducing.
It's a very important bill for all of us. The SARS Act further prescribes the manner in which the weather services is to be managed and governed, including staff and financial matters. The current overall function of the weather services is to provide meteorological services over South Africa. In 2004, the National Environmental Management Air Quality Act number 39 of 2004 was promulgated. One of the legal obligations stemming from the NAMAQA, as it is known, for government was to develop credible and quality information to inform air quality intervention measures or initiatives that are there, as well as to share air quality information with the general public regarding the right to safe air, which all of us has a right to. The legal obligation that the department has is to actually invest in infrastructure for the purpose of creating a credible baseline of ambient air quality information. Now, in order to meet the information requirements for good quality air quality governance and ensure full compliance of the NEMAQA, since the promulgation of NEMAQA in early 2005, the Department of Environmental Affairs established the South African Air Quality Information System, what is called SAQIS, and the National Ambient Air Quality Monitoring Network, what is called NAQUIM, and identified the weather services as a suitable custodian of the South African Air Quality Information System. The Quality Information System, Honourable House Chair, is an electronic web-based information management system that has a stated objective of providing all stakeholders with easy access to all relevant information about ambient air quality in South Africa, and further provides different stakeholders with different useful online applications in order to support the effective and efficient management of ambient air quality. The National Ambient Air Quality collects and feeds information into the information system and consists of networks of government-owned ambient air quality monitoring stations located around the country, South Africa. Both the South African Air Quality Information System and the National Ambient Air Quality Monitoring Networks are already in operation, ladies and gentlemen. Both systems are work in progress that will continue to grow in size and in scope and utility and complexity over the next few years. To ensure the sustainability of these systems, as well as to provide weather services with the necessary mandate and powers to host these systems, the Department and the South African Weather Services agreed that an amendment to the South African Weather Services Act is indeed desirable. In this regard, the source bill provides South African Weather Services with a legal mandate of ambient air quality information and to be the custodian of the South African Quality Information System. The amendment will provide the South African Weather Services with the necessary function and will ensure sustainable operation and maintenance of the air quality information system. The South African Air Quality Information System and the National Ambient Air Quality Networks will be fully institutionalized within South Africa, within the weather services of South Africa. Importantly, for the first time, let me say this, in 20 years of our democracy, government air quality intervention measures and or initiatives will be based on credible and quality information. Honourable Speaker, the source bill provides the Minister with policy determination as well as the supervisory power over the weather services. The Minister will set policy parameters and the weather services must perform within its powers and exercise these functions. The amendment will allow the Minister to monitor the exercise of powers and performance and functions of the weather services against this policy that is determined by the Minister. And the source bill empowers the South African Weather Services to issue ambient air quality forecast and ambient air quality warnings. The ambient air quality warnings will be issued after consultation with the Minister. This is also something that comes as different. The ambient air quality forecast and warning will be informed by the ambient air quality information that's generated from the quality monitoring networks as well as from the system that I referred to earlier on. And these powers and functions must be performed or exercised within the policy parameters that will be determined by the Minister. The source bill also strengthened the corporate governance provision of Clause 7 of the source bill that provides for selection, recruitment, and appointment of the CEO to follow the transparent and competitive process. And thanks to the Portfolio Committee for also bringing this new arrangement. The current provision of the SAWS Act do not contain this provision on the removal of a CEO from office. And therefore, Clause 8 in SAWS Bill inserts Section 13A, setting out details and ground of this removal. The current provision of SAWS provides for the CEO to be the accounting officer of the Chief Executive Officer to be the accounting officer of the weather services, whereas Section 49.2 of the PFMA provides that the board should be the accounting authority.
Honourable
Clause
Minister,
10
your time has expired.
amends this, and I would like to really, as I conclude, congratulate the committee, but also move that this bill be adopted. Thank you very much.
Thank you, Honourable Minister. The next speaker is the Honourable De Lange.
Honourable Chairperson, Honourable Deputy President, Honourable Ministers and Deputy Ministers, members, comrades and friends, ladies and gentlemen, I rise once again on behalf of the ANC and as I hopefully also on behalf of the Portfolio Committee in once again recommending unanimously that we support this amendment bill in Parliament. May I again start off by also thanking my long-suffering committee for the intellectual vigor and honesty with which they tackle their work and the tremendous diligence they show in doing the work, and again to the Minister and her department for the professional and very useful assistance that we receive as a committee. This bill may seem very technical in format. However, there are a few very important governance issues that I think we should take note of. Clause 2 inserts a new Section 2A and B in the Act to provide the Minister with the legal power to determine the policy framework with which the Weather Service must exercise its powers and perform its functions. The policies will be determined and published in the Government Gazette after consultation with the Board. In other words, once the Minister has set the policy framework within which the Board must operate, the Board has operational independence as long as it operates within the policy framework. The clause also provides the Minister with supervisory powers over the Weather Service. The amendment will allow the Minister to monitor the exercising the powers and performance of the functions of the Weather Service against the policy and the norms and standards determined by the Minister, and to intervene into operational matters by way of directive only in the case of non-compliance. Only in the case of non-compliance. Any existing policies of the Weather Service will be tabled within a certain period of time. Maybe I should elaborate on this matter. As you know, the South African Weather Service is an agency which falls within the mandate of the Department of Environmental Affairs. And therefore, as an agency, it performs certain functions which the department would normally have performed. In this case, the functions being performed, of course, those that are dealing with weather services. Now, it's very important that we look at agencies and their relationship they have with departments. In South Africa, I think we are very lax in spelling out those relationships properly. Of course, agencies are used all over the world. It's not a new phenomenon. But what is happening more and more as societies get more complex, as government gets more difficult, more and more functions of government is handed over to agencies. And therefore, the relationship between your government and your agency are very important. In most instances in South Africa, we don't spell out that relationship at all. It's something that we hope it works out, and usually when there's a good relationship, there aren't problems. The problem, of course, is when there's a breakdown. Then not having the proper relationship spelled out does become problematic. So what we've tried to do here, and our starting off point of a score is the Constitution. The Constitution very clearly says in Section 85(2)(b) that it's the national executive that develops and implements national policy. That is the preserve of the national executive of our country. It has to develop and implement policy. Therefore, if we create agencies in our departments that are fulfilling certain functions that that department would usually fulfill, of course, they have to do so with the department retaining or the minister retaining the policy formulation on that aspect. And then, of course, once you've got the policies, then you have operational independence for that agency to act within those policies. And then the minister can only, of course, intervene in those matters with their supervisory powers where there's non-compliance of the policy or norms and standards. Now, it's this relationship that we have spelled out very clearly in this legislation, and we hope that in our other agencies, we have many others in our departments, that we're going to spell out it also much more clearly so that these relationships can stand the test of time and everyone very clearly understand what those relationships are. Clause 3 and 4 of the Act also amend the Act to extend the objectives and functions so as to provide the Weather Service with a legal mandate for the gathering of ambient air quality information and designate as the custodian of SAQUAS. Clause 4 will also allow the Weather Service to issue ambient air quality warnings after consultation with the Minister. And Clause 5 will amend Section 5 of the Act to ensure that the needs of air quality management stakeholders are taken into account by the Minister when appointing the board of the Weather Service. I again want to elaborate here somewhat on explaining this very, very important amendment. In order to meet the information requirements for good air quality governance and to ensure the compliance with the National Environmental Management Air Quality Act of 2004, the Department and the Weather Service developed the SAQUAS, the South African Air Quality Information System, and what we call the National Ambient Air Quality Monitoring Network, which is NAMQA, since the promulgation of this Air Quality Act. The partnership between DIA and the Weather Service is governed by a Memorandum of Understanding. And it's this Memorandum of Understanding that now is becoming legalized by giving that legal mandate to the Weather Services, and not only through a Memorandum of Understanding. Thirdly, as the Minister has pointed out, one of the issues that is happening more and more in our country is that where we have agencies and there is an irretrievable breakdown between the board and your CEO, that if there are not proper laws and procedures to regulate this relationship, you can see that we have interminable court cases going on and on and on. In the end of the day, in fact, the courts are actually legislating for us on how to deal with this matter. So once again in this Act, we have gone and created a full appointment mechanism with all the procedures that have to apply, and most importantly, we have dealt with a comprehensive removal procedure with all the checks and balances and making sure that there is a properly audi artem partem during the processes. And then, of course, we will supplement these procedures through regulations, or the Minister will do so. Fourthly and lastly, you will recall that the most important controversial issue in this legislation, when it was introduced the first time, is there was a huge uproar about the wording of the offences that were created in the legislation. After consultation with the department and with the public, it was very clear that the wording, everyone was happy to amend the wording. It's now been appropriately amended, and no one has any problems with it anymore. And hopefully we do not have to ever use those offences to act against someone. But if they do, they are now very clear, and people will be able to be dealt with accordingly. And that will only be in instances where they give false or misleading weather warnings. That is the instances where there will be a offence created, and they will hopefully then be dealt with according to the law. I thank you for listening and ask the House to support this bill. Thank you.
Thank you, Honourable Member. The next speaker is the Honourable Rogers.
Thank you, Chair. Imagine, if you will, a South Africa without a reliable and unregulated weather service and no dependable weather warnings, where agriculture, industry and ordinary citizens have no access to accurate weather information and forecasts. How would our shipping and fishing industry cope without this vital information? Agriculture could not possibly function without accurate temperature and precipitation information, enabling them to determine planting cycles. How would the airline industry function without accurate weather information? And the Minister is right, this is an important bill. Without the dependable and precise weather services, how would we allow VIP guests to fly into Waterkloof Air Force Base? Or how would we be able to round up the cattle and push them in to the cattle kraal at Nkandla that cost us 2 million rand? Good quality forecasts pay off economically, not by generating large sums of money, but rather by preventing the loss of large sums of money. Weather warnings are important, and forecasts as they protect both life and property. Forecasts based on temperature and precipitation is important to agriculture and therefore traders within the commodity markets. A reliable and regulated service is thus an essential service to develop a nation, and it was with this in mind that the South African Weather Services Amendment Bill is to revise the existing South African Weather Services Act of 2001, which act was to establish the South African Weather Service and its operational parameters. Section 3 of the Act is now amended to extend the mandate of the Weather Service to include ambient air quality information. Since the promulgation of the National Environmental Management Air Quality Act in 2005, the Department of Environmental Affairs and the Weather Services developed the South African Air Quality Information System and the National Ambient Air Quality Monitoring Network. National Ambient Air Quality Monitoring Network, as you heard from the Minister, is a network of government-owned ambient air quality monitoring stations which collect all the data and the information, and this information is fed into the Air Quality Information System, and this information is then accessible to you and I or any interested parties. A further amendment to Section 3 of the Act makes the Weather Services the custodian of the Air Quality Information System. The advantage of SAQUIS for South Africa is it is able to provide accurate, current, relevant, and complete information for informed decision-making. SAQUIS should now provide a one-stop shop for users to access air and atmospheric quality information, centralized and verified applications of the Air Quality Act to facilitate compliance, and vertical integration of the three spheres of government and flexible technological solutions for future air quality management for different stakeholders. Thus, the Weather Services has now added a responsibility of the monitoring and reporting on ambient air quality. Clean air is essential to maintain the delicate balance of life on this planet, not just for us humans, but for our wildlife, vegetation, water, and soil. Poor air quality is a threat and needs to be closely monitored and corrective steps taken where necessary. Section 4B of the Act empowers the Weather Services to issue ambient air quality forecasts and warnings once the Minister has been informed. Subsection 7C of Section 4 then authorizes the Minister to consult with any other relevant minister or any stakeholder on the ambient air quality warnings. One, however, would hope that this section is never used to protect those politically corrected industries from being exposed and for being prosecuted for contravention. The bill has further amended Section 13 of the Act to ensure that the recruitment, selection, and appointment of the CEO of the Weather Services follows a transparent, competitive process and continues to address the removal and disciplinary procedure of the CEO and all terms and conditions pertaining to the post. With the ever-increasing reality of climate change, it is critical that the Department of Environmental Affairs and the Weather Services, through monitoring and information dissemination with the South African Air Quality Information System, focus on adaptation as a key strategy to address the challenges on the impacts of climate change. These progressive amendments are one step closer to addressing the problem of climate change. In closing, Speaker, I must add that I was extremely touched by as reference to me in the last debate as the last Lamiki. I wasn't sure if it was the last Lamiki or the lost Lamiki. But Honourable Minister, it takes me back a few years, and I thought, on a lighter note, after a very long day, I would like to dedicate the following to you. Little Bo Peep has lost her sheep and can't tell where to find them. Leave them alone and they will come home, bringing their tails behind them. Little Bo Peep fell fast asleep and dreamt she heard them bleating. And when she woke, she found it was a joke, for they were all still fleeting. The Democratic Alliance supports the bill.
The next speaker is the Honourable Ferguson.
Honourable Chairperson, Honourable Ministers, Honourable Members, South Africa's Weather Service plays a significant day-to-day role in the lives of all South Africans. It is heartening to know that this Weather Service Bill provides for severe weather warnings after consultation with the Minister, so as not to have bogus reports that could create chaos. Today, the world is faced with a disaster in the Philippines that has destroyed many towns and villages. Thousands of people have lost their lives and property. In South Africa, many communities have been affected physically, emotionally, and psychologically as they are living in areas that are not only waterlogged but built in and around disaster belts. They are severely affected, particularly around the increasingly disastrous winter rainfalls. We see many sad pictures year in and year out of the destruction brought by rain disasters. The weather's adverse effect on farming and agricultural produce, runaway fires, flooded dams and rivers, deforestation, erosion, etc. So, it will be short-sighted for any administration to look solely at weather without looking at spatial development plans and the need to rehabilitate areas, some in extremely remote parts of our country. We need a bigger picture approach. The insertion of advisory alert in Clause 1 provides hope for communities whose lives and livelihood are affected by disrupted weather systems and patterns. They will be able to take what little valuables they have with them should they be advised timelessly of pending disaster and urged to leave the area on time. The best way to protect against major accident occurrences is by maintaining the very high levels of safety as embedded in the government's disaster management plans. We must get it right. Government has a responsibility over the safety and well-being of its citizens. A well-coordinated and cooperative approach with all government departments is needed in the event of environmental and weather disasters. The bill further extends the objectives and functions of SAWS to provide the necessary legal mandate to provide ambient air quality services, and in particular is the custodian of the South African Air Quality Information System. Honourable Chairperson, our air quality is endangered by the activities of persons and entities in the country who ignorantly and sometimes arrogantly release poisonous gaseous substances into the atmosphere. The list is long, including millions of cars that emit carbon monoxide and other particulates into the atmosphere, others who engage in bush burning, individuals in the habit of burning refuse, the burning of agricultural waste, factory emissions, including paraffin burning in our communities. As these various acts ultimately have a huge effect on our weather patterns and an adverse effect on the ecosystem. Chairperson, while we cannot control acts of God, we can certainly be better prepared. Minister, as I said before, this bill may not cause the same excitement as Minister Gordhan's budget speech, but we cannot be without a weather service. Honourable Chairperson, in light of some of the recent breakdown of relationships between CEOs, boards and ministers, as we have recently witnessed in other parastatals, this bill strengthens the management of the weather service so as to provide the appointment and removal processes of the Chief Executive Officer. This bill is a step in the right direction in terms of good governance, weather prediction and disaster management, and credible information. COPE supports the bill. I thank you.
Thank you, Honourable Member. Ngibiza ilunga elihloniphekileyo u-CN Zikalala.
Honourable Chairperson,
This bill, by amending the South African Weather Service Act of 2001, brings a greater measure of certainty to our weather services by extending the powers, functions, and objectives of the South African Weather Services. South Africa finds itself in a geographical locale that potential lends itself to bouts of severe weather both on land and sea. We have extensive coastline and erratic weather patterns. We therefore have a great need for meteorological certainty. In this regard, we particularly welcome this insertion of Section 30A, which obliged the implementation of Resolution 40 of the World Meteorological Organization, which urged members to strengthen their commitment to the free and unrestricted exchange of meteorological and related data and products. Honorable Speaker, no weather forecasting service is 100% accurate, and it is in this vein that we would encourage greater collaboration between the source and private forecasting concerns. The Inkatha Freedom Party supports this bill. I thank you.
Thank you, Honourable Member. Mbiza ilungu elihloniphekileyo BJ Dlomo.
Honorable Speaker, Honorable Minister Malewa, Honorable Members. The South African Weather Service was established in accordance with the 2001 South African Weather Service Act. In terms of its vision statement, the Weather Service aims to provide useful and innovative weather, climate, and related products, services, and through enhancing observational data and utilizing the cutting-edge technology to convert data into meaningful products and services for risk mitigation. Honorable Speaker, as weather and climate knows no national boundaries, international cooperation at a global stage is of the utmost importance for the development of meteorology and operational hydrology. It is therefore important to note that South African Weather Service is a member of the World Meteorological Organization, a specialized agency of the United Nations, which has played a unique and a powerful role in contributing to the safety and welfare of this country. The ANC at its 52nd National Conference noted that South Africa is experiencing increasing severe weather, such as flooding, lightning, thunderstorms, tornadoes, and some areas of excessive heat waves, which is causing damage to our property and infrastructure, jeopardizing human settlements and livelihoods, particularly in the low-lying coastal areas. Conference, therefore, resolved that the ANC-led government should continue to proactively build South Africa's capacity in developing a comprehensive strategy to adapt to the inevitable impacts of climate and weather changes, including the rolling out of basic services and infrastructure planning. In January of this year, a severe cut-off low-pressure systems led to floods in the northeastern parts of our country. The Vembe district and the northwestern parts of the Limpopo province, as well as Mpumalanga province, were both mostly affected by flooding, which swept away bridges, roads, fertile agricultural land, causing deaths and injuries in some affected areas. As a result, the Vembe district was declared a disaster area at the time. As disaster preparedness is important in the case of severe weather events that the South African Weather Service, in cooperation with the disaster management, reaches out to all communities through public awareness programs that aims to educate the public and empower them with ability to act. The aim is to develop a weather-ready nation that knows what to do and will respond appropriately to severe weather warnings. Since its establishment, the South African Weather Service has always been the only official provider of severe weather-related warning for South Africa, in order to ensure that there is a single authoritative voice in this regard. This South African Weather Service Amendment Bill emphasizes that it should continue to issue severe weather-related warnings, but consult first with the minister. To ensure the South African is protected against false, misleading, and or hoax warnings that can result and have unfortunately resulted in the past in undue public panic, related stress and injuries, evacuations, or mobilization of emergency services and subsequent fruitless and wasteful expenditure. Although it has effectively been illegal for anyone other than the Weather Service to issue severe weather-related warnings for South Africa since 2001, it is only now that there are possible criminal consequences for illegal warnings that are being proposed in the amendment bill. In order to ensure that we build our resilience to these weather impacts, we must ensure that our warning systems are efficient, effective, and mostly credible. With the real possibility of increasing extreme weather events, the potential for false, misleading, and or hoax warning significantly undermining public confidence in or appropriate public reaction to us is of real concern. A section is being inserted, though, in this Principal Act that states that no person may publish, disseminate, or distribute in any matter whatsoever any severe warning which he or she knows, believes, or ought to have reasonably known to suspect to be false or misleading, that may incite public reaction and lead to the undue mobilization of resources, public alarm, and evacuation or economic loss. A person who contravenes any of these provisions or subsections thereof will be guilty of an offense and liable, in the case of first conviction, to a fine not exceeding 5 million rands or imprisonment for a period not exceeding 5 years. Furthermore, whether any person is convicted and it appears that such a person has by that offense caused less damage to any organ of state or other person, the court may inquire summarily to the amount of the loss or damage so caused, and give judgment thereof in favor of the organ of the state or a person concerned.
Member, your time has expired.
The ANC supports this South African amendment bill. I thank you.
Thank you, Honourable Member. I now call upon the Honourable WM3.
Thank you, Honourable Speaker. Deputy Speaker, the ACDP is aware that the South African Weather Service Amendment Bill seeks, among other things, to provide the Minister with policy determination and supervisory powers, extend the powers, functions, and objectives of the Weather Service so as to provide ambient air quality services and to act as custodians of the South African Air Quality Information System. In addition, it seeks to align the Act with the Public Finance Management Act and also to provide for offences and penalties. It is certainly the hope of the ACDP that the supervisory powers given to the Minister will be used to add value to the Weather Service and not in any way compromise the work that they do. Honourable Speaker, the responsibility of the Weather Service to maintain, extend, and improve the quality of meteorological and ambient air quality related services for the benefit of all South Africans certainly cannot be overemphasized. As we continue to promote a development state here in South Africa and give effect to the National Development Plan and the IPAP and other related mechanisms to grow our economy, we must forever remain conscious of our role to balance economic and industrial growth with quality air, indeed ambient air, for the health and well-being of all South Africans. The ACDP also welcomes the alignment of the Act with the Public Finance Management Act as amended in Section 17 of the Principal Act. Honourable Speaker, I received a message from a Mr. Andre de Kock, who wanted to know what was being done to preserve our air quality in the light of what he called possible seeding of our clouds with heavy metals, resulting in these metals finding their way into our water and air and possibly posing a health threat to our citizens. Hopefully the Minister will be able to respond to Mr. de Kock's question. The provision of offences and penalties, while a bit over the top for some, hopefully will be a sufficient deterrent to those who put out hoax warnings, which may cost the state thousands, if not millions of rands. And with that being said, the ACDP supports the bill. I thank you.
Thank you, Honourable Member. Oyo Chin, SB 1. I surprised myself.
Thank you. Honourable Chairperson, Honourable Deputy President, Honourable Minister and Deputy Minister, Honourable members, ladies and gentlemen. Firstly, before I begin engaging on the South African Weather Service Amendment Bill 2013, I would like to thank our esteemed and knowledgeable Chairperson of the Portfolio Committee on the Water and Environmental Affairs, Honourable Johnny Dilanga. Initially, when between 6 to 7 pieces of legislation came before the Portfolio Committee, there was some concern as to feasibility of the possession of the legislation within limited time frame. With the sustained effort of the Chairperson, together with the departmental official, for the bill and the two conventions were adopted by the committee on the 29th October 2013. And 3 of the bill has passed last week on the 5th November 2013 by the Parliament. I commend the work of the world concerned. Weather forecast and the warning are the most important service provided by the meteorological professions. Forecasts are used by the government and the industry to protect life and property and to improve the efficiency of the operation, and by individuals to plan a wider range of the daily activities. This summary of the present date weather forecasting the capabilities is intended to provide the general guidance to a broader constituency of the users. Over the past 150 years, the South African Weather Service SOUS has built up a reputation as a trusted provider of the weather and the climate information. SOUS have played an integral role in assisting government to minimize the impact of the weather-related natural disaster. The primary goal of the SOUS is to ensure the continual development of the meteorological product and the service in the compliance with the applicable regulatory frameworks. In relation to the South African Weather Service Amendment Bill, the purpose of which is to amend the South African Weather Service Act 2001 so as to substitute and insert certain definitions, extend the objectives and the function of the South African Weather Service to deal with the ambient air quality information service. Provide for the minister to amend the schedule to the act by the notice in the Gazette, to provide for the offense and the penalties, and to amend the schedule to the act. One of the key aspects that I would like to focus on is the provision to the water service of the legal mandate to provide ambient air quality service and to act as the custodian of the South African air quality information system. By 2010, the importance of the working toward measurable improvement in the South African ambient air quality result in the air quality management intervention that are fully informed by the accurate, relevant, completed, and accessible information. A national air quality information system in the form of the South Africa Air Quality Information System is in the place. Currently, there are the 102 government-owned monitoring stations, and 84 of these are already reporting to the South African Air Quality Information System. ACDP Honorable Member just a question for this. This means that we have the 82% of the government-owned monitoring report to the SAQAS. And this is very impressive, as we have already met the President outcome 10 delivery target to have the 80% reporting. One of the challenges regarding the number of the government air quality monitoring stations, which are mandatorized in the municipalities, are the concern for the national department as well as local government. There needs to be greater deal of the uniformity between the three spheres of the government to ensure air quality monitoring of the higher standards. Another current and critical concern of the global world in this century is climate change. The South African Weather Service with the South African Air Quality Information System, working closely with the Department of the Environmental Affairs, is focusing on the adaptation as a key to the coping with the impact of climate change. In relation to the climate change, adaptation is key to the coping with the unavoidable impact of the climate change, which could exacerbate the large existing variability in the weather and the climate of the regions. To contribute to adaptation efforts, the South Africa Weather Service is improving on its draft monitoring capacity, particularly through the integration of the various data sources and the maintenance of the quality and the distribution of the network for the rainfall and the other key climate observation. The institution also reinforced its climate information system to the integrate climate change projection, information with the historical database for the benefit of the various end users in the water resources, agriculture, health, infrastructure, biodiversity, and the ecosystem, forest, urban management, tourism, food, land, environment, and energy security, and the management of the coastal and the marine resources sector. Chairperson, I would like to take this opportunity to comment after my colleague from the DA, Honorable Rogers, and the COP, Honorable Ferguson, and the IIP Honorable Mama Jikalara for their effort and support of the bill. And especially of the Honorable Rogers, have a miniature of the former member, Mr. Morgan, shadow but not opposed for the object too. Just you say the weather service is linked to the aircraft for the landing. I don't know, it's good weather service and good all information, so this aircraft can land in anywhere. So it doesn't matter, it's landing to the Air Force. So I think it's all committee member is fully supported the chairperson of the committee. I think absolutely is the Honorable Johnny Diranga also to agree with me and appreciate the committee members to cooperate with you and contribute their professional job. Chairperson, in conclusion, I would like to stress that good air quality is a prerequisite for the health and environmental well-being, which are the cornerstone of the sustainable development. We need to achieve economic growth should be balanced with the improvement in the health and environmental well-being. The ANC support amendment bill. I thank you.
Thank you, Honourable Member. I now call upon all the Minister of Water and Environmental Affairs.
Thank you very much, Honourable Chair. To all the members who have participated on this podium in support of this bill, thank you very much. To all the members of the ANC in particular, thank you for being such good educators and actually taking the resolutions of your own party into this parliament and into government and ensuring that sustainable development is attained. This is one of those bills that ensures sustainable development on an ongoing basis. I did say earlier on that the information that we will be collecting through this, the air quality networks and the systems that will be put in place will actually be work in progress, as in continued work in progress, that will continue to grow in size and in scope, as well as in complexity over the next few years. And I think Mr. de Kock should be informed accordingly that this information will help us to be able to prosecute those who are acting against the law. I think that's what you must say, Honourable Member from ACDP, to Mr. de Kock. This is a progressive realization towards that direction. For those of us who are in this committee, I think there's really, I should be standing here and saying thank you. But I want to say that the ANC is a visionary organization, very good vision. And we are really putting in place all the laws that are necessary to ensure that we even protect our people's health through acts of this nature. This bill will do exactly that. So if you really just come on from time to time and not be a Morgan who we long for, not so, Honourable Member Johnny, I'm saying Honourable Member Morgan, who was so educated and understood exactly the issues that we're talking about, would never stand on this podium and refer to Nkandla when it's actually absolutely not necessary. The Premier of this province uses an aircraft every day which has been directed where to go by the South African Weather Services,
Minister, your time
which
has
uses
expired.
this act. Thank you very much. Lat Lameki, thank you.
Thank you, Honourable Minister. Honourable members, that concludes the debate. Are there any objections to the bill being read a second time? No objections agreed to. The Secretary will read the bill a second time.
South African Weather Service Amendment Bill.
The bill will be sent to the National Council of Provinces for concurrence. The Secretary will read the 23rd and the 24th orders.
Consideration of report of Portfolio Committee on Police on Private Security Industry Regulation Amendment Bill. Second reading debate, Private Security Industry Regulation Amendment Bill.
I now recognize the Chief Whip of the Majority Party.
Honourable Chair, I move that the report and the bill be sent back to the committee in view of, I can't see this. Thank you.
Order, order, please, order.
I move that the report and the bill be referred back to the committee and that permission be given to the committee in terms of Rule 249, subsection 3B, to inquire into amending other provisions of the legislation. I so move.
I now put the motion. Are there any objections? No objections. Agreed to. The Secretary will read the 25th and 26th orders.
Consideration of report of Portfolio Committee on Justice and Constitutional Development on suspension from office of Magistrate FKS Ntuli, and consideration of report of Portfolio Committee on Justice and Constitutional Development on provisional suspension of Magistrate J.F. van Schalkwyk, Chief Magistrate at Kempton Park.
I now call upon the Honorable L.T. Landers to introduce the reports.
Honorable Chairperson, I rise to present to you our reports on two magistrates. The first one is Magistrate FKS Ntuli. As you will recall, Honorable Chairperson, we appeared before this House asking for Magistrate Ntuli to be suspended provisionally, pending the outcome of disciplinary processes within the Magistrates Commission. Those processes have been finalized, and Magistrate Ntuli was found not guilty of the misconduct charge leveled against him. Consequently, the Commission is of the view that it cannot justify the continuation of Mr. Ntuli's provisional suspension from office and recommended that the Minister lift the suspension with immediate effect. Ours then is to say to this House to please confirm the lifting of Magistrate Ntuli's suspension. I then present to you, Honourable Chairperson, our request for the provisional suspension of magistrates Ms. J.F. van Schalkwyk, Chief Magistrate at Kempton Park, who is alleged, amongst other things, to have refused to execute a lawful order, derogatory and disrespectful and insulting behavior to both the Chief Magistrate and the Chief Justice, severe abuse of power as judicial head of the office, especially with reference to the magistrates under her control, by utilizing them for non-official purposes during official court hours, gambling during official hours, borrowing money from subordinates and an attorney who deals with her court hours in an official legal capacity, and finally, defeating the ends of justice and making misrepresentations to the Judge President in Gauteng during her stint as an acting judge by handing down judgments that were not written by herself but by magistrates under her control and on occasion by an attorney. So, Chairperson, we're asking this House to uphold the provisional suspension of Magistrate Ms. F.J. van Schalkwyk on the grounds that I have just mentioned. Thank you.
Thank you, Honourable Member. Honourable Members, are there any objections to the adoption of the recommendation of the committee? Order, please. Can I finish? Are there any objections to the adoption of the recommendation of the committee, namely that the upliftment of the provisional suspension of Mr. FKS Ntuli be confirmed? No objections? Are there any objections to the adoption of the recommendation of the committee, namely that the provisional suspension of Ms. J.F. van Schalkwyk from office as magistrate be confirmed? Are there any objections? No objections. Agreed to. The Secretary will read the 27th order.
Consideration of report of Portfolio Committee on Arts and Culture on oversight visit to public entities and historical sites in KwaZulu-Natal province from 31 July to 2 August 2012.
I now call upon the Honourable T.B. Sunduza to introduce the report.
Thank you, Chairperson, and thank you, honorable members. I'll just quickly present the report on our oversight in KwaZulu-Natal. We went to a few different museums, starting with the Msunduzi Museum, which includes the Ngome Museum, the KwaZulu-Natal Museum, the Albert Luthuli Museum, and the declared grave sites of liberation stalwarts of President J.T. Gumede, J.L. Dube, Albert Luthuli, and Betham Keys in KwaZulu-Natal. I must say, Chairperson, it was one of our most honorable visits that I must say. First, to say that the Albert Luthuli Museum was one of the most well-managed museum in this country. And further to say that, Chair, secondly, that the graves have been declared, and then Sarah, we're just waiting a few issues that they need to change on. Going to the grave site of J.L. Dube and the school, there were few concerns that the portfolio committee raised. First being that the museum is at the school, and then how about the visiting hours? But further to say that we request that the roads be improved, and the issue of marketing must be improved as well, in order that these museums, because they tell a history of South Africa, then it must be highly marketed as well. But I must say, we must thank the KwaZulu-Natal province as well for supporting these museums as well. But further to say that, Chairperson, as we visited the Msunduzi Museum and Ngome Museum, one of the issues that was raised there was the issue of the roads that are going to the Ngome Museum, which is a bit far. But one of the issues that we further raised was to say that there's an issue of reconciliation that as South Africans were raising now, to further say that a bridge should be, as it has been done at the Fort Trekker Monument and Freedom Park in Pretoria, it should also be done in Ngome Museum as well. We must say one of the issues that made us to raise this issue was that it was a gravel road to go to the museum, and then during the rainy seasons it becomes very, very difficult to utilize them. But further, one of the reports that we raised is to say that the Department of Public Works has to meet with the Department of Agriculture in order to speed the processes that Public Works must improve. This is one of the issues that was raised when we went to the gravesite of President J.L. Dube, that this Public Works has been delaying this issue of purchase, but we request today that as an amount has been given, it must be administered as well as quickly as possible. But to further say that, Chairperson, we may compliment the way the Albert Museum, Luthuli Museum is working with the young people in around KZN in the area of growth and community of Groutville, you know, because they engage a lot of parties and they strengthen their working relations with the local municipalities as well. In addition to that, there were few also challenges that were raised, and the portfolio committee also observed. To say one of them is the operational space and the facilities constraints and the fund of sustainability, because they only rely on the department only. And then we said also there must be there's a lack of proper signage from the N2 and R02 highways leading to the different museums, and the insufficient museum acquisitions, you know, and there are a lot of high community expectations and aspirations that are supposed to be met. Further to say that one of the issues that we complimented on the greening is the greening of the Luthuli Museum as well. I must say, Chairperson, I would encourage honorable members to visit these sites. It must start with them. They've got no issue of being which political party you come from. It's a history of South Africa that one has to understand. You know, Honorable Van der Berg, oh, well, he's here. He was very happy to say that to visit such sites as South Africans is to promote the issue of reconciliation, and he was happy to visit them. And I invite honorable members on my left also to visit them. But I must say, Chairperson, one of the issues that I want to quickly raise is that the issue that we raised with the grave of Umama Upeta was the issue that there's a lot of theft around, and we raised an issue because there's an issue of breaking the tombstones of those we've erected that we are honoring. There's a lot of theft, and the issue the province has taken the matter and the municipality forward. I'd like to thank you all the honorable members of the portfolio committee and all the staff members, and we hope to see you in these museums in KZN. Thank you, honorable members.
Thank you, Honorable Sunduza. I now recognize the Chief Whip of the Majority Party.
Honorable Chairperson, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objections. We now come to orders number 28 to 37. Together as they appear on the order paper, these are the reports of committees on public accounts. I now call upon the Honorable N.T. Godi to introduce the report.
Ngiyabonga Sihlalo. Comrades and honorable members, on behalf of the Standing Committee on Public Accounts, I wish to present to the House the second to the 11th reports of the committee. These being reports on the annual financial statements and the report of the Auditor General on the Independent Communications Authority of South Africa, the Department of Correctional Services, the Department of Labor, the Public Service Commission, the National Agricultural Marketing Council, Promotion of Petroleum Exploration and Exploitation, South African Housing Fund, Energy Africa Rehabilitation, International Frontier Technologies, and the Council for Mineral Technology. Of these, only the Department of Correctional Services had a qualified audit opinion. This remains of great concern to us as a committee, saying that the department seems unable to get itself out of a qualification. Even though over the years there has been improvement, but the qualification issues remain grave. Issues around procurement and contracts, human resource management, especially leave and overtime management, asset management, expenditure management, especially those related to irregular expenditure as well as fruitless and wasteful expenditure. Going forward, we think that it will be important for us as a committee to confer with our comrades in the Portfolio Committee on how we get this right, because it just cannot continue like this. The Department of Labor and ICASA are unqualified but have serious emphasis of matter that, if left unattended, will lead to a qualification. Of concern, among others, are expenditure and performance management, procurement, that is supply chain management policy compliance. We are hopeful that ICASA, in communication with its leadership, appears to be making progress, so it has been with the Department of Labor. Comrades and honorable members, we are not just harbingers of bad news. It has always been our practice and desire to present those departments and entities that are exemplary in their performance. The 7 entities presented above have clean audits. That is, there are no material findings by the Auditor General in their compliance with laws and regulations. And these are the Public Service Commission, the National Agricultural Marketing Council, Promotion of Petroleum Exploration and Exploitation, the South African Housing Council, the Energy Africa Rehabilitation, the International Frontier Technologies, and the Council for Mineral Technology. I present these reports to the House for adoption. But before I leave the podium, comrades, I must thank my comrades in the committee with whom we work in a very collective spirit, and the same will go to our administrative staff for their hard work, which has seen the committee succeed in fulfilling its mandate. I thank you.
Thank you, Honorable Godi. I now recognize the Chief Whip of the Majority Party.
Honorable House Chair, I move that the reports be adopted.
The motion is that the reports be adopted. Are there any objections? No objections. The Secretary will read the 38th order.
Consideration of report of Portfolio Committee on Basic Education on study tour to Botswana.
I now recognize the Chief Whip of the Majority Party.
House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objections. The Secretary will read the 39th order.
Consideration of report of Portfolio Committee on Health on study tour to London, United Kingdom.
I now recognize the Chief Whip of the Majority Party.
Honorable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objections. Agreed to. The Secretary will read the 40th order.
Consideration of report of Standing Committee on Appropriations on follow-up oversight visit to Limpopo and Mpumalanga provinces from 22 to 26 July 2013.
I now recognize the Honorable E.M. Sogoni to introduce the report.
Thank you, Honorable House Chair, Honorable Deputy President, honorable members. The Section 27(1)(b) in Chapter 2 of the Constitution of the Republic of South Africa provides that every citizen has a right to access sufficient and clean drinkable water. The Constitution gives national and provincial government authority to regulate local government in terms of water services. In 2010 State of the Nation address, His Excellency President Zuma stated, I quote, the government shall not falter until each and every community in our nation has clean potable water, because our water supply forms a strong backbone to all social and economic development initiatives. In the light of this recognition on the strategic importance of water provision, the Standing Committee on Appropriations undertook a second follow-up oversight visit to Limpopo and Mpumalanga provinces from the 22nd to the 26th July 2013. The aim of the visit was to follow up on a similar visit which was undertaken by the committee in 2010-2011. The visit had been informed by ongoing interactions between the committee and Department of Water Affairs during the in-year monitoring of its expenditure. The committee conducted a workshop with stakeholders on the 23rd of July 2010. It visited two areas, two dams, one the Nandoni water bulk distribution system and the Inyaga water treatment works. The Nandoni water bulk distribution system is in Thohoyandou in the Vembe district. Honorable Chairperson, I think that the committee was happy with what it found out there, because there was a commitment, and the committee was also convinced that the water will be, the people, the communities will be able to receive water by the end of December 2013. And on proceeding to Inyaga Dam, we found that there was cooperation between the Department of Water Affairs and Mpumalanga Department of Cooperative Governance and Traditional Affairs. And again, the committee was convinced that the people of Bushbuck Ridge will be able to receive running water by the end of July, because of the coordination and the seriousness that the issue was taken by the department and its partners. On that note, Chairperson, I would like to ask the House to adopt the report. I thank you.
Thank you, Honorable Sogoni. I now recognize the Honorable Chief Whip of the Majority Party.
Honorable House Chair, I move that the report be adopted.
The motion is that the report be adopted. Are there any objections? No objections. Agreed to. The Secretary will read the last order.
Consideration of report of Standing Committee on Appropriations on study tour to Uganda and Kenya from 29 June to 6 July 2013.
I now recognize the Honorable the Chief Whip of the Majority Party.
Honorable House Chair, I move that that report be noted.
The motion is that the report be noted. Are there any objections? No objections. The report is noted. Honourable members, that concludes the business for the day and the House is adjourned.